That is the high court against the additional activity under the project. That was the kind of order methods. Corrected the address. Now we have corrected address. That's what we must be corrected. Any date 50 on the active one week against the district of 50. Published. Of the list, item 1 and 2. A substantial portion of the claimed by Lordship in 18.2, Lordship of Frame, additional substantial portion of law, 18.2. That was regarding the donation of child, pension, family pension, paid, the applicant be divided. The regulation itself, the 95 regulation, is very clear. Take any things between son, means sort of born out of the void marriage or valid marriage, that there are discrimination of that disparity is not there at all. And as far as the definition of family is concerned, the son is considered to be son, then he will take the pension in the entirety. And any other person will be not in there. That would be as per regulation 2, 1, 2, family.
Yes, Mr. Hawk.
Verdict. See, but this is on Christian. So it will be guided by the Indian succession. The Indian Succession Act, there's a detailed like that. Okay. That is
Maybe not the property.
Pension and gratuity of all the pension if it is the property. Not that the property.
So you say that this particular provision, the regulations has to be read with the Indian succession.
Case of Hindu Malad, case of Western and Madam.
So as per the first appellate court's judgment, the appellant hearing have been granted, minor have been granted something.
We are not finding any appeal against that. Fine. It's shared.
Who is the defendant number one?
And mother and sisters are
Who is the defendant number one?
tenant number one here is the bank. Others are the sister.
Now kindly come to the first appellate court's judgment of which judgment I'm looking. Title appeal, appellate court judgment, only come to page 17.
First two and three. Decision of first two and three. The first appellate court has come in. Find it page 13. And page 7. Keep finding the first two and three. Okay, the plaintiffs are the only legal heirs of deceased Vipul Musari, whether the defendant who is the legally married wife of the deceased Vipul Musari, and the defendant number three is the legitimate child of the deceased. From this issue number 4 and 5.
Now, the trial court judgment say, page 63, declaration that the mother and all sisters and the son are entitled to the decree for final settlement of dues. Page 63. That's the order passed by the learned trial court. You got it, George? So we are concerned with what is the amount which is in respect to this. Means all dues.
Yes. All other dues are already paid or adjusted. But the other dues other than the family pension, such as gratuity or leave encashment, they have either been paid or they have been adjusted in the loan. Because the deceased had a running loan taken from the bank.
So what is the effect of 2A? The relief 2A. Page 63. Are you not having a page number
Yes.
similar to this court? Huh?
Correct.
So what is this?
But we have
Why should I take up this? You people are not prepared. Okay.
260 or 14.
I don't, I'm not going to take up this matter. What is this? After hearing this matter for such a long time, both of you are not having the page?
No, we have paid it. It's taking 260 or 14 or we have two appeals. 60 or 14 and 44.
260. What is the other appeal for?
It's 43 or 15.
What is the other appeal for?
It's the arising from the same. There are two suits. Both were tried together.
Why there are two appeals filed?
With two suits. One filed by me for declaration, the other filed by them. So their suit was allowed. to that extent. Ours was partly allowed. The claim of the wife, that is appellant number one, that was rejected, and the claim of the son was upheld to that extent. So there are five people on the other side, on this side. So effectively, what the court decreed is that both the courts decreed that there will be 6 shares of the pension. That is the case. But whether
Sir,
they-
but family pension can the sisters get?
No, that is because what has happened here, my contention is that even the mother would be out. Because the mother would be barred, by the provision of the 95 regulation. Because the parents will only come in when the deceased does not leave behind a widow or a son. That is the categorical.
No, but can you both come up in tandem with this court at regards page 63 or not?
The 63 the issue number 4 and 5 in the RSA 43 of 15,
Page 63
page 60.
is the trial court judgment.
Trial court's operative order.
Then
Issue numbers 4 and 5.
both of you have it or not?
I,
You're not given a proper copy.
copy them. The numbering perhaps whether okay. Given the serial number is also different. Page number is different. 63.
You have the trial court judgment.
I think judgment is the same. I will take from the other.
Have you got it or not?
Fine.
Both of you can't, all this
I've been-
while the matter has been heard before this court, both of you have not seen to this, that the file, what is the page number of the file?
I have pictured the entire C1, C2 file also. I think. Yeah.
So whatever two A, what is the effect of two A?
Yes. Declaration that named Sri Musahari, mother, Rita Musahari, Rahila, Sulekha Musahari, Kamala Musahari, and Mila Musahari, all are sisters.
Do you have the trial court judgment or not?
Have.
Then have you seen two A? The order? Or no? You don't have a trial court judgment?
Have.
Give it to me. Give me your file to me. Let me show it to you. This is a disgusting type of assistance to this court.
Copy has been submitted.
Forget about the copy. We are only concerned with the judgment of the trial court. There is only one judgment of the trial court. Or how many judgments are there?
One.
One. Then can't we find it out? How many suits are there?
The PS number 8 of 2005, which they have filed with us. And subsequently, PS 28 of 2006, which I have. We have. Two different suits, but order same.
There are two suits or one suit with one counter claim.
In fact, first of all, they approached me. They approached the court.
But why do I find a counter claim somewhere here? In this
There was
file?
a counter.
Huh?
There was a counter. There was a counterclaim which they filed. They filed the counterclaim in my suit. In the
So
second,
there are not two suits.
in fact, it was
There
treated.
was one suit and one counter claim.
Yes, it was treated as a suit.
Huh?
Two suits, Manoj. One suit, TS 28 of 2006. That is my suit. That was dismissed. only the son's share was allowed. And the other one is that, filed by them, PS 18 of 2007. That they had filed for declaration that they are the legal rights of the late. Of the
So how
deceased.
many judgments were there?
Judgment panel, effectively, there's only one judgment.
Not effectively. This suit is dismissed.
One is dismissed, in my
So there are two judgments.
yes.
Are you not aware, Mr. Ganguly?
I-
How many judgments are there?
Two,
Then why are you saying that one judgment?
two judgments.
That you will allow. Both judgments same date? You are not aware. Hello. The counsels for appearing for both the parties do not have the proper files for which the matter stands adjourned, silent. Release from pardon.
But we have,
Absolutely no. This is not the manner in which you assist this court. Why haven't you given him the proper file? The file in which page 63 is there in my file, it is 46 in his page. How is it possible? No, absolutely no. How is it possible that you have given him a different thing from what I am holding?
I have paginated from both.
The
sides.
steps having not been taken, let me dismiss the appeals on that ground. Steps having not been taken as per law. Dismiss the appeals.
The appeals were
No,
dated later.
nothing
The
doing.
court record.
No, nothing doing.
I have
Here there is a court record wherein the page starts from here. Page 1, it starts page RSA number 260 of 2016.
Yes.
Finally come to page 63. His page, it is page 46, isn't it? Then how is it possible? You have given a different copy to him. You have not taken the steps properly
tell you what,
on this ground, and we impose a cost of 50,000 each. You pay it. It is absolutely the fault of the council for which the appellant is going to suffer.
okay.
No, nothing doing. I am not concerned whether you are the council or not. When the matter has been parted for such a long time, this is the reason why.
We have come to the paging
Therefore,
there in copy.
Taking into account that the council appears, the council for the appellant appears to have not filed the proper document, furnished copies to the other side, and the appeal has been heard. It would not be proper on the part of this court to hear the appeal with defective papers being furnished to the council appearing on behalf of the respondent. Accordingly, the appeal stands adjourned to be listed on such date as the registry may decide, find deemed fit, release from part of it. Absolutely.
I'll give the copies.
No, nothing doing.
That paging.
Nothing doing. This is not the way in which you are prepared.
Actually, I am not the council.
I am not concerned. When the matter is being heard, how is it possible that you have done it?
Pointed out, by the other side, the paging is different. I did not know, maybe perhaps my learned fellow also may not be aware.
He is aware. He is aware that you have not
Yeah,
given him the proper copies.
They itself only he has come to
Next matter. Not going to take up this matter.
not the.
I released it from party. I'm not going to take up this matter. Hurry. I've been taking up the matter seriously, framing questions of law so that it can be, both the rights can be protected, and this is the manner in which you are dealing with it. Absolutely no.
They itself, it is something like that they are copies, they may not have the proper.
No, nothing doing. I'm not going to have it. Let it go, whatever it has.
Not you going to deal with it from part of today. Now itself I'll give it from part. Take it up after a few days.
No, nothing doing.
But she was heard it.
I have heard it, but the manner in which, the manner in which the learned counsel for the appellant have taken up this matter, it does not inspire the confidence of the court for which the matter stands adjourned, listed on such date at the registry may release from Item 3.
We'll give the copy. Or at least a date will be.
No. Registry with me. Not going. That is not to be listed before. Yes. Mr. Sahu.
Last provision, we got.
Paragraph 9, page 36.
In my humble submission, it is the lot of which I take time.
This is a finding.
Because we not, that decision was filed against the order of not passing state.
Why on earth you did not bring to the notice of the court then, at any point of time, at the passing of the decree, that you had some right over that land?
Because that in the proceeding, I was not party member. I was not party. And secondly, yes, this honorable court, last occasion means in the second hour, say that there is enough representation. That representation so far as relates to the inheritance from my grandfather, not to the independent right.
The land, in that case, the suit was filed for the suit premises, the house. They are going to go ahead with the execution of the house. Forget about the land, I'm not concerned.
But
How you-
otherwise, indirectly,
Whatever may be, the question over a house being given, the government have not given you the khatiyan over the house. Khatiyan has not been given over the house. So under such circumstances, that granting you even a khatiyan has no relevance.
well, ultimately, I will be dedicated to the.
But Mr. Sahu, the learned counsel is here. No, nothing we hearing on behalf of the petition. Petitioner. Mr. N.C. Das, the learned senior counsel, assisted by so-and-so, appears on behalf of the respondent number 1, 2, and 3. First, the petitioner has approached the court by invoking the supervisory jurisdiction of the court, by invoking the revisional or supervisory, the revisional jurisdiction of the court under section 115 of the Code of Civil Procedure 1908, challenging the order dated 12/12/2024, passed in title execution case number 5/2019 by the learned court of the civil judge, Junior Division, Naharkatia, Dibrugarh, hereinafter referred to as the learned executing court. First, the question arises as to whether this court is required to exercise its for ascertaining for the purpose of deciding the the legality, for the purpose of deciding as to whether this court should exercise its revisional jurisdiction in respect against the order, in respect to the impugned order dated 12/12/2024. It is relevant to take note of the brief facts which led to the filing of the instant proceedings. First, the respondent number 2 herein had filed a suit being title suit number 23/1975 against the grandfather of the petitioner, who was one Tonkeso Dwara, decades since deceased. First, The case of the respondent number 2 in the said suit was that the respondent number 2 was the owner of the quarter situated at Old Staff Line at Naharkatia Estate, which was given to late Tonkeso Dwara as a condition of his service. Huh? As a condition of his service. Subsequent to retirement, comma, the late Tonkeso Dwara as an incident of his service. Subsequent to his retirement, late Tonkeso Dwara did not vacate the suit premises, for which a notice was issued on 6/3/1974, asking him to quit, vacate, deliver vacant possession of the quarter on the expiry of 31st of March 1974. The late Tonkeso Dwara, however, did not vacate the quarter, and it is under such circumstances. The suit was filed being title suit number 73/1975 for recovery of khas possession of the suit premises by evicting the defendants and his dependents therefrom, and for cost of the suit. Where the degree? The said suit thereupon was decreed in favor of the respondent number 2 by the learned trial court on 19 by the judgment and decree dated 19/8/1994. It is very pertinent to mention that during the pendency of the suit, late Tonkeso Dwara expired, and he was substituted by his wife, namely Malshana Dwara. Maishana Dwara. Being aggrieved by the judgment and decree dated 19/8/1994, passed in title suit number 23/1975, the grandmother, the said Maishana Dwara, was the grandmother of the petitioner, preferred an appeal before the first appellate court, which was registered and numbered as title appeal number 15/1994. The said appeal was dismissed by the judgment and decree dated 31/5/1995. Late, she also died. Being aggrieved, a second appeal was preferred by late Maishana Dwara before this court in the year 1990, which was registered and numbered as RSA number 128/1995. And the same was also dismissed on 31/10/2000. Upon the dismissal of the said second appeal, an execution application was filed on 16/6/2011, which was registered and numbered as title execution case number 11/2011. It is relevant to take note of that after the filing of the said execution application in the year 2011, the petitioners filed a suit in the year 2011, which was registered as title suit number 49/2012, seeking a declaration that the decree obtained by the respondents herein was null and void, illegal, inoperative, and unexecutable due to fraud and misrepresentation. And the defendants and the respondents herein had no right, title, and interest to execute the said decree. Semicolon. A declaration that the petitioners herein, as well as their dependents and person under them, are not liable to be evicted from the suit premises described in the decree, as well as also for perpetual injunction. Also, in the said suit, the petitioners herein, as plaintiff, sought for a stay of the execution proceedings, being title execution case number 11/2011. The said suit subsequently was renumbered as title suit number 4/2022. 4/2022, in view of the fact that the said suit was transferred.
That should also be dismissed, my lord. By judgment decree.
No, that I know, don't worry. I'm writing it. You have not mentioned, I've already mentioned all that. The said suit being title suit number 49/2012 was transferred to the court of the learned Munsif, Naharkatia, in view of the amendment made to the Bengal Assam Agra Civil Courts Act 1887, whereby the pecuniary jurisdiction of the court was enhanced. It is further relevant to take note of that in the execution proceedings, the petitioner had also filed an application under Order 21, Rule 29 for stay of the execution proceedings in view of pendency of title suit number 4/2022. This application under Order 21, Rule 29, filed by the petitioner before the learned executing court, was dismissed by the learned executing court by an order dated 28/5/2022. And it is under such circumstances, being aggrieved, the order dated 28/5/2022, passed by the learned executing court, was challenged before this court by invoking the supervisory jurisdiction of this court, which was registered and numbered as CRP IO 270/2022. This court, by the detailed judgment and order dated 26/4/2024, dismissed the said application filed under Article 2 to 7 of the Constitution, thereby affirming the judgment passed by the learned executing court of rejection of the application under Order 21, Rule 29. It is very pertinent at this stage to take note of some of the observations made by this court while disposing of the said application, being CRP IO 270/2022. Paragraph number 9 and 10 of the said judgment, being relevant, is reproduced hereunder. 9, 10, and 11 is reproduced hereunder. Mr. Ensitas, the learned senior counsel appearing on behalf of the respondents, further draws the attention of this court that title suit number 4/2022 have had also been dismissed by the learned trial court on
On 21/9/24.
by the judgment and decree dated 21
21/9/24.
9/2024. Appeal filed and an appeal there against have been filed,
Title appeal number 47 of 2024.
which is registered and numbered as title appeal number
47
oblique
of 2024.
2024
Of the Court of the Learned Civil Judge, Senior Division.
before the court of the learned senior
Civil judge.
civil judge senior division.
Division.
Dibrugarh.
Dib-
It is further relevant to take note of that after it is further relevant to take note of that pursuant to the dismissal of the application, dismissal of the uh, application filed before this court being CRP IO number 270/2022, comma, the learned executing court passed an order on 27/5/2024 in title execution case number 5/2019. And passed an order that passed an order directing issuance of writ after proper verification. Thereby fixing 15/6/2024 for taking steps. On 15/6/2024, the judgment of the petitioner filed a petition number 298/2000/24. And the learned executing court fixed 1/8/2024 for hearing on the said petition and necessary order. This court finds it very relevant to take note of the said petition being petition number 298, wherein the petitioners sought review of the order dated 27/5/2024 on the ground that the judgment debtor number 2, one Bhavani Prasad Dwara, have not been served with the notice. And secondly, that the preliminary objection dated 16/10/2012 and the final objection dated 13/5/2022 are yet to be heard and disposed of before proceeding with the execution of the case. Pusto. The learned trial executing court, by an order dated 1/8/2024, dismissed the said application, which was registered as petition number 298 by the detailed order and holding inter alia that the said order that the review jurisdiction could not have been exercised against the said order. The review jurisdiction could not have been exercised. Pusto. The petitioner and Pusto, the learned trial executing court further, having taken into account petition numbered 430/2024 filed by the decree holder, fixed the said petition for hearing on 22/8/2024. The petitioner therefore did not stop. The petitioner again approached this court by filing another application by invoking the supervisory jurisdiction of this court under Article 227 of the Constitution, which was registered and numbered as CRP IO number 435 of the 2024. The said application, by the said application, the petitioner challenged the order dated 1/8/2024 on the ground that the preliminary objection was on the ground that the preliminary objection raised on 16/10/2012 and the final objection filed on 13/5/2012 was yet to be disposed of. And without disposing of, the learned trial court, the executing court had proceeded with the execution. This court, by an order dated 4/11/2024, dismissed and by an order dated 4/11/2024, did not interfere with the order dated 1/8/2024, but rather disposed of the petition by directing the learned executing court to hear and dispose of the preliminary objection as well as the final objection before issuance of the writ in the said execution proceedings. It is under such circumstances the order, impugned order dated 12/12/2024 was passed by the learned executing court, whereby the preliminary objections so raised were disposed of, and thereby directing the preliminary and the final objections so raised by the petitioners as judgment debtors were rejected, and fixing 16/1/2025 for taking steps. And it is under such circumstances the present revision application has been filed. Mr. Yes, what is your case now? Mr. S. Sahu, the learned counsel appearing on behalf of the petitioner. Where is your preliminary objection?
At
Let me-
page 24.
Huh?
Page 24.
Final objection. Yes. So page 24.
Yes.
Mr. S. Sahu, the learned counsel appearing on behalf of the petition, submitted that the learned executing court failing to take note of the objections so raised by the petitioner before the learned executing court. He submitted the objections raised to the executability of the decree were as follows. A. The execution case was filed on 16/6/2011, which was barred by limitation under Article 136 of the Limitation Act 1963. Number two, B. The decree holders had earlier filed title execution case number 16/2008, which was dismissed for default on 30/4/2009. And as the decree holders have failed to take steps on the other judgment debtors, including Bhavani Prasad Deora and the decree holder, instead of getting the said title execution case number 16/2008 revived, filed the present execution application, which was registered and numbered as title execution case number 5/2019. Isn't it? Is it 19 or 21? Oh, it was different, no? Five only 2019. Why is that become 19? It was filed where? When did he file it? 2011.
That around their subdivisional code was there. It was transferred from
Was numbered as initial number was
initial number was 1111.
11/2011. Later on numbered as 5/2019. Number three. See, the suit premises was wrong, not properly described. And as such, the execution proceedings was not maintainable. So four. It was further mentioned that the total land measuring 1 bigha, 1 katha, 10 lechas, that is 18,720 square feet of dark number. Dark number what? Huh?
I looked at.
The longer the judgment, the longer is the higher is your cost. We have now reached the cost of 1 lakh. Tag number 4. Covered by key periodic patta number 1. There was more, there were more, there were standing more than 1/4 since the time of the forefathers of the petitioners and had been let out to different tenants on rent, and in respect of which the DC Dibrugarh had issued a Rayati Patta in favor of the judgment debtor, late Hari Prasad Dwara. Hari Prasad is your grandfather, father,
Prasad was my
father.
Amit Dwara. Because all the beginners were not met by the institute. That idea.
You raised that issue also. You have raised that issue also. The Mr. Additionally, it was also stated,
No, because in the execution itself,
you have raised it, no?
Yes.
Additionally.
And page-
Number 4. The decree so passed was null and void, taking into account that all the legal representatives of late Tonkeswar Dwara were not made parties to the said suit. The learned counsel therefore submitted that these objections were not taken into account by the learned trial court, learned executing court in the proper perspective. And as such, it is a fit case wherein the entire execution proceedings is required to be rendered non-est. Non-est. And the impugned order dated 12/12/2024 is required to be interfered with. Because if that objection is allowed, then the execution proceedings will become non-est and as such and interfere with 12/12. This is your submission. Mr. NC Das, the learned counsel,
into this, Patian has been issued. And
you have already mentioned that.
there is a bar under section 66 of Temporary Settled Areas Financing Act. And no civil court has jurisdiction.
What is 68? What is 68? What is section 68?
66 of
Why, what is 68? First, you see the book and then make submissions before this court. Don't make the submission just for the sake of it.
it also, because this suit was not as big as landlord and tenant.
So, who is the landlord? Who is the landlord as of now?
They are.
Isn't it? Yes, having a section 66, you don't bring in. And you see the note thus down below, there's a judgment. It will not come under 66, it will come under 68, isn't it? Now it is 1,25,000 as of now. And this is, one has to teach you a lesson. It has to go to around 10 lakhs by the time. it finishes. The learned counsel further submitted that in view of the Rayati Khotian being issued in favor of the father of the petitioners by the DC in respect to the land The said the further execution, the execution proceedings is barred under section 66 of the Assam Temporarily Settled Area Tenants after Assam
from temporary settled areas, Tenancy Act 1970.
71. For short, the Act of 1970. Or contra, Mr. N.C. Das, the learned counsel appearing on behalf of the respondent, submitted that this is a the the filing of the instant case and the objections so raised before the learned executive court are nothing but attempts made by the judgment debtor to delay the fruits of the decree upon the plaintiff, oblique the decree holder. The learned senior counsel submitted the right to the decree so passed by the learned trial court have been upheld by this court as far back in the year 2000 itself. And till date, even after a passage of 25 years, the petitioner, the judge, the decree holders are not in a position to enjoy the fruits of the decree on account of unnecessary objections being raised by the judgment debtor. He therefore submitted that this is a fit case where exemplary costs should be imposed and the costs should commensurate with the deprivation of the petitioner of the decree holders, even after the decree has been confirmed by this court. 25 years. This is how the cost is till now 125. It will go for it. Having heard the learned counsels appearing on behalf of the parties, let this court first take up each of the subjections so raised by the learned counsel appearing on behalf of the petitioner as regards the execution proceedings and the order, impugned order dated 12/12/2024. The first objection so taken pertains to that the execution proceedings is barred under Article 136 of the Limitation Act 1963. First, this court have duly perused Article 136 of the Limitation Act, which stipulates that the period of limitation is 12 years. No, Limitation Act. Which stipulates that the period of limitation is 12 years when the decree or order becomes enforceable. In the instant case, it would be seen that the learned trial court decreed the suit I am making it long for your purpose only. Cost. Decreed the suit by the judgment and decree dated 19/8/1994. The said decree passed by the learned trial court was affirmed on merits by the learned First Appellate Court entitled Appeal number 15/1994, whereby the said appeal was dismissed on 31/5/1995. Full stop. The said judgment and decree passed by the learned First Appellate Court dated 31/5/1995 was further confirmed on merits by the division by this court by the judgment and decree dated 31/10/2000 in RSA number 128/1995, applying the doctrine of merger, comma, that the enforceability of the decree would be and and applying the doctrine of merger, comma, the period of limitation and terms with Article 136 is required to be taken with effect from 31/10/2000. In the instant case, it would be seen that the second execution application was filed in the year 2011. Under such circumstances, the said application seeking execution was filed within the period of limitation. Let this court now take up the second objection so taken. As regards that the first execution application, which was registered as title execution case number 16/2008, was dismissed for default on 30/4/2009, and the subsequent application filed was barred inasmuch as and the subsequent execution application could not have been filed. The said objection, in the opinion of this court, is totally misconceived, inasmuch as Order 9 of the Code of Civil Procedure is not applicable, inasmuch as it is well settled that the provisions of Order 9 of the Code is not applicable to proceedings under Order 21 of the Code. Considering the above, the provisions of Order 9, Rule 9 would not come into play. Under such circumstances, it is also well settled that there is no bar to filing fresh execution applications, but within the period of limitation. Accordingly, the second objection so taken, it is misconceived, for which the same stance was rightly rejected by the learned executing court. The third objection has been taken is as regards the wrong description of the suit premises. At this stage, this court, the said objection reminds this court of the judgment of the Supreme Court in the case of, in that name, 2003-7 SCC, wrong description, 2003-8 SCC. Take my book. So there the court has given the costs should be imposed. So that is why I'm bringing it. Now it has gone to 2. And 50,000 is yours. This is the third round of meeting. And this has to be finished once for all. Because just passing judgment, Mr. Das, you'd never get. Just passing and dismissing him will not help anyone. Let him go to Supreme Court once for all this matter. You take, I am a very free and I am dealing with Mr. Sahu. The same objection so raised reminds this court of the judgment of the Supreme Court in the case of Ravinder Kaur versus Ashok Kumar and others, reported in 2008, 38 SCC 289, wherein the Supreme Court categorically observed that raising a dispute in regard to description or identity of the suit scheduled property or a dispute in regard to the boundary of the scheduled suit property at the execution stage is only a bogey to delay the eviction by abuse of the process of the courts. It was observed that the courts of law should be careful enough to see through such diabolical plans of the judgment debtors to deny the decree holders the fruits of the decree obtained by them. These type of errors on the part of the judicial force, it was also observed that the court should act with a firm hand in dealing with such type of objections. This court further finds it relevant to take note of that neither at this time of finds it relevant to take note of that neither at the time when the suit was filed, when evidence was led by the defendants, there was no issue raised either in the pleadings or in the evidence as regards the incorrect description of the suit premises. In the opinion of this court, such steps, such objections so raised at this stage amounts to an abuse of the process of the court. Paragraph number 22 of the said judgment being relevant is reproduced herein under. In that view of the matter, the third objection so raised is totally misconceived. Next. The fourth objection so raised is regards that the DC Dibrugarh had issued a royalty patta in favor of the father of the petitioners. And it is under such circumstances the execution proceedings should not be allowed to continue. This court finds it relevant to take note of the observations so made this court in the previous segments of the incident judgment had quoted paragraph number 9 of the judgment dated 26/4/2024, passed in CRP IO number 270/2022, wherein this court had categorically observed that the issuance of a khatiyan would only be a khatiyan in respect to the land and not in respect to the scheduled premises of the suit. It was also observed that the khatiyan was issued during the pendency of the suit, and as such any devolvement of rights during the pendency of the suit could be only subject to the outcome of the further proceedings of the suit. Full stop. This, these observations so made by this court have not been assailed in any further proceedings, and as such, the said observations act as bar on the part of the petitioner to raise such objections. Additionally, this court further finds it relevant to take note of that the perusal of the plaintiff categorically shows that what was sought perusal of the plaintiff would categorically show that the recovery of cast possession was sought for in respect to a suit premises which was a quarter allotted to the grandfather of the plaintiff as an incidence of service. Full stop. The said quarter had categorically been categorically been described in the schedule to the plaintiff. Full stop. This court further finds it relevant to take at this stage the judgment of the Supreme Court in 2003. In the judgment. What is that judgment? I forgot. 2003 2 SCC on where it says that order 7 rule 3, order 20 rule 7, it can be corrected at any stage. So which means they also think. Well, Prithviraj. This court further finds it relevant to take note of reminds of the judgment of the Supreme Court in the case of Pratibha Singh versus Santi Devi Prasad, reported in 2003 2 SCC 330, wherein the Supreme Court categorically mentions at paragraph number 17 that when the suit is filed for recovery of cast possession of an immovable property, when a suit for immovable property is decreed and the property is not definitely identified, the defect in the court record caused by overlooking the provisions of Order 7 Rule 3 and Order 20 Rule 3 is capable to be cured. After all, it was categorically observed that after all, a successful plaintiff should not be deprived of the fruits of the decree. Full stop. It was observed that the learned executing court can exercise its powers under section 47 of the code to ascertain the exact description of the secret decretal property. Paragraph number 17 of the said judgment is reproduced here in under. Next. This court further finds it pertinent to take note of whether your Rayati Khutian
That has not been annexed.
Ah.
Okay. That
have
has
you
not been-
enclosed it before the trial court, executing court?
Hello?
Have you enclosed it before the executing court?
Because to lead evidence was not, you are not. given.
But you have not even put the photocopy. Number is also not given. This court further finds it also very interesting to take note this court further finds it very pertinent to take note of that though in the objection there is a mention that the DC Dibrugarh had issued a Rayati Khutian Patta in favor of the father of the petitioner. But neither the date on which such Rayati Khutian was issued, nor the number of the said Rayati Khutian have been stated in the pleadings. There is also nothing on record as regards to show that there is any issuance of Rayati Khutian in favor of the father of the plaintiff, of the petitioners.
They have admitted.
Forget about them. Under such circumstances, the said objection so taken is totally misconceived, is untenable and misconceived, and it's just a bogey to delay the fruits of the decree to the decree holder. The last objection so taken pertains to that in the suit, all the legal representatives of late Tonkeso Dwara were not made a party, and as such, the said decree would not affect the rights of the decree holder. Rights of the would not affect, the said decree cannot be would not be applicable insofar as the other is legal representatives of the respondent of late Tonkeswa Dwara. This court finds it very pertinent to take note of. Your father was because I remember this aspect, your father was a substituted appellant in RSA, isn't he? Do you know that? Are you aware of that? Your father was the substituted appellant in the RSA? Isn't it, Mr. Das? Where's that RSA judgment? Because that I have duly taken note of then. And I got hold of Mr. P.J. Saikia, who was appearing then. But you have not been properly instructed. So for that, another 20,000. Hey, judgment to legation. RSA number?
RSA number 128, 128 of 1990.
1.
128. Okay. 1995.
Date of judgment is?
At 110 to 2000. Yes. Why discussion with secretary, my lord? Here has been to judgment level was right that giving that 6 months time to get it down, get it just to
Within 6 months.
whatever the me and the teacher for doing a contempt proceeding.
Contempt would not lie. Contempt lies when I give those orders for vacating. I mean. That is, or judgment to hold, judgment hold, death hold,
3110, you have to have.
10. This court takes note of that this very issue was very raised before the in second appeal number 128 oblique 1995, and this court in its judgment and decree in its judgment dated, what is the date of the judgment?
3110, 2000.
31/10/2000 had categorically observed that the said as a substantial question of law was raised before the second appeal number so and so as a substantial question of law, and this court by judgment dated so and so rejected the said contention, and this very aspect can be seen from the impugned order dated aspect is apparent from a perusal of the impugned order dated 12/12/2024, whereby the learned first executive court have mentioned in paragraph number have duly mentioned. Taking into account the above, but itu mo bhai di mana itu judgment to level. Copy ata lagi bili. Sign kora. I think your father because your grandmother died
By the
and as such he was made. Because this is what was placed before me when I passed that order. If I'm not wrong. That's it. But anyway. এটা কত লাগে? Judgment to fight. Any more grounds? Taking into account the above. In addition to that, this court have also duly taken note of that the taken note of the impugned order dated 12/12/2024, whereby the learned executing courts meticulously have taken into account each and every objection so raised by the petitioner and upon applying the law properly have rejected the objections so raised and proceeded with the execution proceedings. Consequently, this court it is the opinion of this court that there is no error in exercise of jurisdiction by the learned executing court, nor the impugned order dated 12/12/2024 suffers from any illegality or material irregularity in exercise of the jurisdiction. Consequently, this court finds no merit in the instant revision petition for which the instant petition stands dismissed with cost quantified at rupees 2,50,000.
too high.
25.
25,000.
25. I put it 25,000. This is required. This is too much.
And I didn't know nobody will come to me.
Huh? You want to again come?
If lordship, you put this rupees 1 lakh, other day, next time nobody will come to me because. Sorry.
I'll fix it on that date,
That's similar issue in limitation
13/5, na?
13.
We'll have it on 13/5, huh?
They prefers, two items are there only, 10, 11 dollars. Same order may be faster. 10 and 11 comes. 10 and 11 orders.
Who is paying for that?
Lordship, there is the problem is that my lord justice service could not be effective. Yet to be effective. In item number 11, response number 1 has appeared.
I mean, now, without justice service
Yes,
accommodation, why you couldn't affect?
well, that has been issued by both the, company has developed some individual to serve the public. That has not been done. I have been instructed to do nothing.
Okay, do one thing. Both these items on 13/5/2025. As similar matters are being taken up by this court. And in much as this similar issue is being taken up by this court in CRP IU number 111/2025. 24. The, both these matters be tagged along with CRP IU number 111/2024. In respect to 10 and 11, 10 is cited that Mr. T. Quilter, the learned counsel appearing on behalf of the appellant submits that the justice service could not be affected upon the claimant. First of all, he however submits that he may be given an additional opportunity. Taking into account the above, list this matter on 13/5/2025. Full stop. Full stop. The petitioner hearing shall affect justice service upon the respondent numbers 1, 2, and 3 by way of registered as 1, 2, and 3, no? What? 1, 2, claimant.
Yes, my lord. 1, 2, and 1, 2, 3, 4.
1, 2, 3, 4. 1, 2, 3, 4 by way of the state, routed to the registry of the court and file an affidavit of service on or before the next. Item number 11 to 10, no? Hetu, list this matter along with CRP IU number 111/2024 on 13/5/2020. With the interim orders passed in both the here also, these also.
10 and 11.
Now, these are dismissed.
Yeah. Yes,
These are dismissed. 4 and 5 are dismissed. 10 or 11 of interim orders will continue till the next. Come on.
Item 6. What happened?
Your lordship. Your lordship, we have just received this, brief last night itself.
Who are you?
Here for the, this, your lordship.
Who are you?
I'm appearing on behalf of Mr. H. Omar, your lordship. H. Omar, your lordship.
Yes.
H. Omar.
Yes.
Yes. ASTC.
Ask him to argue.
Your lordship, he is unable to appear before this court because of his, today is his father's charge, your lordship, so he is unable to
Make it.
Your worship, kindly grant us a leave.
No, nothing. You keep on changing. There are three sets of lawyers. Every time when I take up the matter, you change. You dismiss your petition. You go ahead with the criminal case. You dismiss his petition. Heard, Mr. And so the learned counsel appearing on behalf. Okay. You have filed the Wakalatama? But then none appears for the petition. Not filed the Wakalatama. None has appeared on behalf of the petitioner when the matter is being taken up. Petitioners, when the matter is being taken up. Mr. DCC Kupon appears on behalf of the petitioner. It is taken note of that by an order dated 22/4/2025. This court had observed that the petitional affidavit filed by the managing director of the petitioner corporation that was not satisfactory. In as much as the said undertaking so given was not explicit. And further to that, the undertaking did not reflect that the managing director was authorized to give that undertaking before the court. This court further, in the order dated 22/4/2025, had categorically observed that the Assam State Corporation Limited, being a state within the meaning of Article 12 of the Constitution, cannot be permitted to retain possession of the land of the respondent hearing without following the due process. It was also observed that the said act on the part of the petitioner corporation is in flagrant violation to the mandate of Article 300A of the Constitution. This court further fixed the matter on 29/4/2025 with the direction that the respondent petitioner corporation shall bring on record the list of assets as well as the bank accounts of the ASTC. However, neither the petitioner has appeared nor filed such, petitioners have appeared nor filed such affidavits, which therefore shows that there is a willful and deliberate attempt to undermine the majesty of this court. Considering the above, this court's direct fixes the matter on 6th of May 2025 directing the personal appearance of the managing director of the ASTC to be present before this court to the video conferencing mode. Also, the registry shall intimate the managing director of the ASTC of this order forthwith. If he does not appear on personal appearance, tell him, we put him behind bars. We ask issue a warrant against.
Implemented item 24.
So, Chaudhary, yes, what do you think? I was thinking about this matter. I've asked him to file an affidavit. What they did, they filed an affidavit including a report. Only on report and report.
But these are not functional. These are not functional. Absolutely wrong statement.
But it's okay. Let them put that report, the contents of the report in the affidavit. I think it would be, what
Yes,
they
I
are
could follow.
what they are trying to do is just imposing a report, thereby later on put the responsibility upon that officer. He made a mistake. So let them file an affidavit because my observations were very clear that they are to file an affidavit as regards this. But what they enclose is a report. So that affidavit cannot be said to be satisfactory.
Because they will rely on that report.
They will say the report he has given me a post.
So let them make specific amendments.
Government on the basis of the report or whatever may be. This court has put them that specific. File an affidavit. Secondly, what about that Prasanthi Lodge? Yeah, in this matter, there are different councils appearing from time to time.
There was one more Mr. I wanted, his mother had a. Both of them are.
Then let us have the commissioner and secretary, additional chief secretary present. I think better off if the councils are not helping out, so we'll have the additional chief secretary present. Because first of all, that affidavit does not seem to be in conflict. Chance to the forest department to file an affidavit by Iman. It is observed that in the server, no affidavit is filed. This court should presume the has not taken any steps in regard to those resorts. So the forest department would insist upon the impugn notice that this was in view of that, this court have perused the affidavit in opposition as well as the averments made. The replies to those averments made in the affidavit by the referral are satisfactory. This should have been told to file an affidavit indicating whether this so. So let the divisional forest officer be present in the court. As there is no counsel. No, nothing like no. This court cannot spend time like this. For this matter, one day, it cannot happen like that. This was fixed on that day with Mr. B. Gogoi saying that he is going to come up with this observation. Then one day delay here means that there is another matter which is time is being taken for another matter. Do you think it is so easy? Managing the court hours? Then tell me. Then what happened? Why?
As per my instruction, there was flooding in his area.
Huh?
There was flooding in his place.
Nothing. There's no rains. All the courts, all lawyers are coming out here and there's flooding out there. It is seen that this court, the records show that by an order dated 26/9/2024, this court have directed the divisional forest officer Punitpur West Division to file an affidavit in respect to the query, along with providing the map indicating wherein the above mentioned resorts camps are situated. There was no affidavit filed when a matter was taken up on 4/11/2024. And it is under such circumstances this court observed that if the forest department does not file an affidavit, it shall be presumed that the forest department have not taken any action against those resorts, the details of which have been mentioned in the order dated 26/9/2024. It is further seen that from the report, it is further seen that an additional affidavit was filed on 14/11/2024 by the Divisional Forest Officer, Punitpur West Division, wherein there is no statement made by the Divisional Forest Officer, but what was mentioned therein, what was relied upon, was a report dated 12/11/2024. If the said report is true, then why, if this court fails to understand as to why the details of the report have not been incorporated in the affidavit, in as much as when on affidavit it is stated, it is the same can be very well taken as a statement made before this court. Considering the above, this court does not find the additional affidavit filed on 14/11/2024 to be satisfactory. This court further, on 24/4/2025, taking into account the report dated 12/11/2024, inquired with the learned counsel appearing on behalf of the Forest Department as to whether the permission to allow the Prasanti cottage within the Nameri Tiger Reserve Forest had the acceptance of the central government as is required under Section 2 of the Forest Conservation Act 1918. No information, however, have been provided by the learned counsel appearing on behalf of the Forest Department in that regard. On the other hand, it is also taken note of that the petitioners have filed rejoinders to the affidavit filed by the Divisional Forest Officer, wherein it denied that the report dated 12/11/2024. And the details in that regard have been mentioned in paragraph number 6. The said documents, the said statements made in paragraph number 6 is further supported by various documents enclosed to the said affidavit. With photographs shown to have been taken on 25/4/2025. Taking into account the above, this court fixes this matter again on Ms. So-and-so, the learned counsel appearing on behalf of the Forest Department, submits that she has no instructions in the matter. Taking into account the above, this court fixes this matter Can we fix it on 8th of May? On 8th of May, 2025. Or 13th,
13, yes.
on 13th of May, 2025. Full stop. Thereby directing the divisional forest officer to bring on record its stand. Bring on record by filing an affidavit as required in terms with the order dated 26/9/2024. And also dealing with the allegations contained in the rejoinder filed by the petitioner. Today. Today, na? Today. Today. Full stop. It is observed that if there is no response from the respondents, from the divisional forest officer on the next concerned divisional forest officer on the next day, this court would have no other option but to seek the personal appearance of the said officer. If the interim order custody shall continue till the disposal of the matter.
25,
In this case, you ought to directly me to finance the policy matter that I have to file.
What has happened?
Our claim was this minute as it not maintained it. In
Why?
view of 165 of it. That was the finding of the tribunal.
You are the owner.
Beg your pardon?
You are the owner of the vehicle.
Now I am. Yes, I am. And I dropped the vehicle, I dashed to the roadside divider and I died.
So yours is only on the personal loss.
Yes.
Can a
not protect-
personal loss be done in the tribunal?
Yes, ma'am. In view of this policy, I am entitled.
No, no, but can it be done before the tribunal?
Tribunal. But my landed friend court window has filed it. Since it has been dismissed, that's why I have come before it.
No, it's okay.
I
But the
could not say
question
that. I
is-
think they pointed out that I could have approached the insurance company directly. But
You have to go for the insurance company and then to ombudsman.
some must- Otherwise, it must.
But I don't think that motor vehicles. We have.
That's why, but since it has not been considered with the court below, my limited prayer will not dispose with the direction how to approach the insurance company.
I think that is the best way of. Mr. Gustami. Although you are not there,
The authority, but he can say. that.
you were an authority in motor vehicles. You see, he had his own insurance. There was an accident. So it is first party. Now the first party, he has not got the amount. So he filed it before the Motor Accidents Claims Tribunal. But I don't think Motor Accidents Claims Tribunal can adjudicate that. It has to go before the ombudsman or the consumer forum. Consumer forum will also come in.
No, sir, what is specifically covered for personal accident. That matter can be taken up with the company first. If they don't take it, then they can go to almost.
Or the consumer forum. And if it is not, he is not a commercial, then obviously he can do it through the, this consumer.
If
If the insurance company declined to insure my there.
Then you can go to consumer. That is the only way.
See, that I want from you.
I think that is where I will therefore say that the order has been rightly passed, but it shall not bar you from approaching the appropriate.
Yes, you know, it is the ignorance of my understanding, Mr. Pilot. He could have approached this.
An appeal heard Mr. S.C. Biswas, the learned counsel appearing on behalf of the appellant. Is an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the judgment and order dated 5/9/2024, passed by the learned member Motor Accidents Claims Tribunal Sriram Azalda in MAC bracket death case number 22 of the 2023, whereby the claim proceedings was dismissed. This court had duly taken note of the facts which led to the filing of the instant proceedings. Well, although the instant appeal is taken up for disposal at the stage of Order 41 Rule 11 of the code to ascertain as to whether the present appeal is a fit case to be admitted and thereby to call for a records. The materials on report show that on 15/7/2023, one Sudem Hazari Narzari while coming in his own car bearing registration number AS25J 6335 from Belkol Bazaar towards Belkol Gate at about 12:15 a.m. at night, lost control and knocked on the divider near the road. And resultantly, the vehicle fell into a water canal. The said Sudam Hadnarzari suffered injury and died on the spot. On the basis thereof, the claimant joined together and filed the claim proceedings, being MS, which was before the Motor Accidents Claims Tribunal, Sidang at Kazalda, which was registered as MAC death case number 22 of 2023. The learning tribunal, by the judgment and order dated 5/9/2024, came to a finding that the said claim was not maintainable under section 165 of the Motor Vehicles Act 1988. Inasmuch as the tribunal set up under the said act could decide the compensation only to a third party. It was also observed that in view of section 165 of the Act of 1988, the claim of the claimants pertain to personal accident cover as is admissible for the insurance policy. And the such claim can be raised against the insurance company in the appropriate forum. Taking into account the above observations were made in the impugned judgment and award order dated 5/9/2024, and further that the that the appellants herein are not uh, are first party, claimants. They cannot, this court finds no ground to interfere to admit the instant appeal, for which the instant appeal stands dismissed. Be that as it may, this court, however, observes that the dismissal of that the judgment and order dated 5/9/2024 in MAC death case number 22 of 2023, as well as the dismissal of the present appeal, shall not affect the rights of the claimants, public the appellants herein, to seek redressal from the insurance company, concerned insurance company, as well as the other forums available under law.
Carrying under order 41 rule 2 CPC, items 7 and 8.
Your people are viable dependence of the.
You're on caveat,
Yes, sir.
huh?
Initially, this one. Not admitting.
What is the motive business?
9/12.
Anyway, I won't hear you. Tell me, what is your case?
Well, the case, the suit was initially filed, by the respondents hearing. The suit land is 2 bigha, 1 kattha and 14 lessers. And in fact, this 2 bigha, 1 kattha, 14 lessers is the disputed part of the land. So there is other land, total land comprises 7 bigha, which we are not concerned with. We are only concerned with 2 bigha, 1 kattha, 14 lessers. The plaintiffs claim to be, the co-sharers and also the legal rights.
You're a plaintiff.
No, they succeeded both in the trial court as well as the first. But their claim was that these 2 bigha, 1 kattha, 14 lesser was sold. In fact, they did not say sold. They said that we have by communication. The appellant in the item number 7, she is in possession of 1 bigha, 2 kattha, 10 lessers, and appellant in item number 8, 4 kattha, 4 lessers. And the same suit, same judgment. The claim if reduced, while for duration of right title, interest, recovery of class position, etc. The plaint only says that the land, portion of the land which belong to brother of the plaintiff number 1 and father of other plaintiff, that land has been occupied by us. The plaintiff does not, the plaint does not say when the land was occupied by us, when we came into, when, what is the date of this?
the ground?
Ground, first of all, that the claim itself, claim itself is silent as to when the defendants have dispossessed the plaintiffs. There is no such whisper. There is, it is only mentioned that the land belonged to so and so. And we have rotated our lands, and there was a case which they filed before the executive magistrate for attachment, etc. And that decision, that verdict went against the plaintiffs, and therefore, my lord, they have decided to execute. There is no whisper in the plain that when the defendants have come into the court. So, the plaintiff has to mention, my lord, that the disposition occurred on a particular day, or at least some rough date. That is the first requirement. And my lord, even the claim does not contain anything regarding as to when the cause of action. In fact, there is no reference to any cause of action. Claim is totally silent. The plaintiff only says, my lord, these facts that the land belongs to so and so, who was one of the co-partakers, and on such and such date, mutation has been done by the defendants. We went to the executive magistrate. Executive magistrate has decided against us. They filed a revenue appeal. Revenue appeal was dismissed, and thereafter they have filed a suit. That listen to the suit. The claim, as I said, is silent on the plaintiffs. Because the plaintiffs have to first of all at least plead. Proof comes later. Plead that the plaintiff is within the limitation because of ABCD.
So, Mr. Ganguly, once they have a title, once they have a title, if they ask for recovery of possession,
Yes.
if they ask for recovery of possession,
Yes, they have asked for it.
recovery of possession, then you are to say why you should not be, why you are to be there.
That defense I have taken of adverse.
Now you have taken the plea of adverse possession.
Yes.
Now the adverse possession question is, what have you taken? What is your ground of adverse possession?
My ground in the adverse question is that we have been in the possession of the property of these lands for the last 20 years. So, and that is admitted by the PW1, PW4, PW5 in the first exam. So, they have categorically said, in fact, PW1, who is the plaintiff, so the plaintiff, who is the brother of the Patadar, who actually sold and handed over the property to us. He categorically says that 20 years they are in possession, and because we failed before the executive magistrate, so that is why we have come files.
Understood. But maybe you are there. You may be there for 100 years. So,
The fact remains that they have also admitted that the Patadar handed over the land to us and then signed in the chitta book and left the suit.
so then
Yes,
where is the
basically
question of
abandoned.
adverse possession? Where is your question about the adverse possession?
My position was never permissive. My position was not permissive. They have said in their evidence.
Whether it is permissive or not, but you are in occupation.
Yes, I'm in occupation.
But what acts have you done to show that you are in occupation? How did you get your Sita mutation?
That was in 2013.
On what basis?
The basis, whatever is there in the plain text.
No. What is the basis of your Sita mutation?
It was handed over on the, it was written by the Patad.
So, Pattadas have written, so that becomes your permissive possession.
That he has handed over the possession. He said
So
that
therefore, woman he has handed over, that becomes your permissive possession,
permissive.
unless you have a title.
Title was originally of the Patad. That is not very.
So therefore, you are not challenging the title of the Pattada at any point of time. By 2013, the Chita mutation happened. So,
2013, the Chitta mutation.
so you are dealing with the Chita mutation of 2013, that you are there, and then you have to show that you have a better title to remain out there. But if you are saying that Chita mutation is based upon that the Pattadas have allowed you to reside there.
No, not reside. It's not a question of reside. But the Patadar has left that land in our favor.
So in
That
your
is why
favor,
the
have relinquished the land in your favor, whatever may be.
Yeah.
But you then also, as of 2013, you acknowledge that this Patadar is the owner.
That acknowledgement per se is not
The
mentioned.
moment you are relying on the Chita mutation, that is the acknowledgement.
I'm not denying.
Who is relying?
The plaintiff, sir.
Are you not saying about the Pata? Let us see your written statement.
Yes,
What did you say?
we have said regarding that.
No,
but we have
let us
not
see your
relied upon
written statement. Where is your written statement?
page 17.
And he handed over the possession and signed the Sita book, and in the year, the names of the year was mutated. Kindly see, this is your statement at paragraph number 4. Then
1033. The statement is not happily, that much
I am not concerned with which is better drafted or not drafted well. You are poking holes into the claim of the claim, but you said that now when I catch hold of you of the written statement, then you say it is not properly.
here is the case. But I'm not on that. What I'm saying is that before going into that aspect of the matter, before going into the adverse question, the plaint itself also has to satisfy the element that the plaint is itself within the universe. Now, they are basically the reliance is upon Article 65.
Huh?
They are basically the case is covered under Article 65. That's what the case is. That
65, it is what?
uh,
Let us assume that they come under 65. Whose plea should be 65? Plea is yours.
is my plea now.
So therefore, why should they say? Let us see the judgment of the Supreme Court in the case of Maria. See the judgment of Maria, wherein in paragraph number 62, what the Supreme Court says, the moment the title is over, it becomes a suit for ejectment. Then kindly see paragraph number 67. It categorically says you are to show a better right. Now, what is your better right? You are claiming adverse possession, thereby claiming at paragraph number 4 that he sold this land to me and I did my Sita mutation on 2013.
Chitta mutation 2013, but much before that.
But why did you acknowledge in 2013 taking that mutation?
Reason that because this was a case of an oral sale. It's an oral sale.
Understood. Oral sale does not happen.
The Chitta
Are these
mutation
people
is not-
Mohammedan? Both. Are these both people Mohammedan? No. These also would not.
The respondents here in they are
They are Adivasi.
They are Adivasi. Now, but
Sir,
as far as the mutation is concerned, mutation happened in 2013. But the admitted case, admitted by their own witness, is that we have been in possession, and we were not in possession as a tenant. We were, and it is admitted.
Let us assume that you were given possession as owner. But as on that date on which you were handed over possession and the Chitta mutation was done,
The Chitta mutation was done in 2013, but I was in possession much prior to that.
where is it mentioned in your plaint? Written statement.
For 20 years, we have been able
Well,
to
then-
it is barred by the.
No, there's nothing mentioned. You even didn't say when you were handed over possession.
That date is not there.
So what is your substantial question of law to dismiss?
By the humble submission to base that.
You have caused unnecessary pain to Miss P. Bhattacharjee to appear. They had to engage her. So it's a case of cost.
No, so here in this case,
But normally order 41 rule 11, I don't dismiss with, I dismiss with, without cost. But here is the case, cost has to be imposed.
here, the plain itself also must show that it is the date of disposition. That is a, that's a decide.
Not necessary.
If I may rely on one judgment, so
Please.
what should be one judgment?
Sir, I'm not going to. Don't worry, go to Supreme Court with that.
But the positions,
There are so many judgments wherein it says that the adverse possession aspect has to be proved by the person who is claiming adverse possession. Not one, hundreds. And here it says that to the effect that if the plaintiff does not say, after getting a declaration of his right title interest along with recovery of caste possession, recovery of caste possession is a consequential relief. It has to follow with the declaration. That is the basic postulate. Therefore, I'm not relying.
you didn't.
Go to Supreme Court so that judgment, the Supreme Court may help you out. But I am not going to.
Look, one more thing, the positions of the admissions made by the plaintiff number one himself. He says that for 20 years, we're not there because they've been there for 20 years. I have filed this suit for everything because they've been there for 20 years. And in light of those admissions, it did not fall upon this judgment perhaps would come in such a case, where there is an admission by the plaintiff himself that look, they are in position for the last 15 or 20 years. And therefore, I have brought this to evict.
But how do you take care of that Maria jail?
We are just ships are
Absolutely clear on this.
that
If you are in possession, you have to show better right
Yes.
as to why you should be in possession. Whatever may be. Otherwise, the plaintiff, when it is a suit for recovery of the possession, it has two facets. One is title and the other, the second is possession. Once the title is satisfied, then comes the question of possession, ejectment. Then the burden shifts upon you to prove that why you should be there. That is paragraph 67. Now, if that is the law, which is based upon various other laws which have been laid down by the Supreme Court from time to time. Anyway, we'll take it up at 2 and discuss both. I'm not going to record your presence.
I have to appear because my client is different. So I have to.
If you want to record your presence, then you have to impose cost upon it.
the positions of PW 1, 4, and 5.
Why should I look into it?
So they are.
We are at the stage of order 41 only. Then the court has called for the records, it's a different thing. Why should I look into it? Unless you say that you have been able to prove adverse possession.
Because my case is admitted by themselves. PW 1, 4, and 5 have said that these people are in possession for the last 15, 20 years, and that is why.
I'm saying it. Let us presume that you are in possession of 30 years.
Because it is not because it is a hostile position, because it is not a permissive. I am not there as a
No, by admitting out there in the Chita that you have taken over the possession on that day. No,
for bringing my name into the what is
so
Chita.
therefore you duly recognized in 2013 when the Chita mutation was there that he was the owner.
That's for the purpose of the revenue. That is, I have
Whatever may be, but you recognized his ownership on that day. That is the problem.
that for in itself would not stop the time which has already started.
No. The moment that you are acknowledging, just for example, that you may have crossed the 12 years. Then one fine day you enter into an agreement with him. Tell, look, yeah, I'm going to pay you rent. No, I'm giving you an example. You pay rent. And then you say, no, forget about this agreement. We have done on a mistaken advice. But we had this 12 years. Your Chita mutation is the deadly weapon against you.
Mutation would not perhaps take away the aspect. Because Chita mutation is a formality which we have to parties have to do because to bring my name in the revenue record. That
So there you recognized him as the owner. The other appeal.
Let's, try the other defendant. Two defendants, same judgment.
Same judge.
Same, same.
He deliver one judge.
If submission to that will not be deemed to silent to when they will dispose this. To remove. Second being that cause of action when arose, that is also silent. That is not mentioned. There is no paragraph regarding cause of action. That cause of action that has been taken to be the date of location by the Lennon trial court as well as by the first appeal. Please, then support of that. I will permitted to read that the positions of the position with us.
We have not raised that issue. That it is not in conformity with order 7 rule 1.
Yes, sir, issue. Not raised. Then that one issue has been told regarding whether it is cause of action.
Cause of action is there.
So that is issue will be regarding issue number one. Whether it is cause of action there. But specifically, there is no paragraph regarding the.
So therefore, why haven't you raised that issue? In your written statement.
Had the written statement been in place, I would have been on the other side. Other side. But I had also placed another judgment on the last. In fact, this matter was once heard by a lordship. She was very.
On that day also I wanted to dismiss it. But one thing could it, because of showing that particular judgment, now I have got another 9 judgments against.
But I had also
And
placed one judgment on the last occasion regarding that oral sale part. Said that sale is there, adverse position cannot be brought. I placed one judgment, that is 1994 SCC 706, Achal Vyakti. There was the distinction between an oral sale and, that is, for example, an agreement for sale. That was there, that was, say that when there is a case of oral sale, or a say, let us say, a Kacha sale deed, adverse position will flow, because it's a sale which is not recognized in law. You do recognize the title, but from that day onwards, you don't recognize. So there is the animus part.
So, but in your written statement, you categorically say that there is no tampering with the records and it is the father of the plaintiff have signed on the papers in the year 2013.
Only the chita, but
Whatever may be. So till then, you have duly recognized his father to be the plaintiff's father, the father of the plaintiff number 3, 4, and 5 to be the owner.
that is not stated there as such, so many words.
No, it is categorically mentioned in your written statement. Paragraph 6. Page 17E. Fact, you see, what is the fault in the judgment of which you are placing before me is this. Fail to take into consideration difference between section of Article 142 with Article 60. Because there, Article 142 required that when a suit is based on title, he has to also show that he has been in possession for the last 12 years. Within these 12 years, he has filed. But on the other hand, 65 makes it clear that the suit based on title has to be filed within 12 years from the date the possession becomes adverse. The possession would only be adverse when the defendants claim adverse. And for that, it is the bounden duty of the defendants to prove that. This is the fundamental flaw in that.
The burden has now sort of changed from the others. That is there, no, that.
But Mr. A. Ganguly, the learned counsel.
The admission of the plaintiffs.
Huh? Now I will take it that the plaintiff says that you are there for 20 years. But the fact that whether the 20 years is worse is the question which you have to prove.
Specifically, well, there was no date fixed, or there was no, let us say, statement that goes to that effect. But once the plaintiff says that he is there for 20 years, I have filed this suit because he is there for 20 years. Well, that itself, well, amounts to an admission, well, of fact. And that admission of fact, well, shows that they were out of possession of the suit land for 20 years.
So what?
So these people, one has to.
So unless it is your proof, that is why I'm saying this is a fundamental flaw in that judgment which you have shown about 65. 65 cannot be like that. One judgment of the Supreme Court is very nice to say. It is 2024 SCC online SC 3846 Malabba. So here the Supreme Court say very nicely. It is therefore obvious that when a suit is based on title for possession, once the title is established on the basis of relevant documents and the other evidence, unless the defendant proves adverse possession for the prescription period, the plaintiff cannot be non-suited. In C, Mohammed Yunus versus so and so. It has been laid down that in a suit for declaration with a further relief, the limitation will be governed by the article governing the suit for such further relief. In fact, then the Supreme Court said, in fact, a suit for declaration of title to immovable property could not be barred so long as the right to such a property continues and subsists. When such right continues to subsist, the relief for declaration would be a continuing relief and there would be no limitation. The principle is that the suit for declaration for a right cannot be held to be bad so long as the right to property subsists. Then they refer to another year and say that it is well settled that when there are several reliefs claimed in the suit, the limitation period would have to be that of the main relief, the limitation for ancillary being ignored. The argument of the learned counsel appearing for the appellant hearing is not sustainable in law as long as it proceeds from the assumption as if the whole Article 142 of the earlier limitation was enforced. Wherein the plaintiff who has based his case on title has to prove only title, but also possession within 12 years had undergone a metamorphic sea change as we find in the Limitation Act. Say Ganguly to Learned Council appearing on behalf of Chaudhary appeal on behalf of appellants in both the appeals and Chaudhary. Learned Council appears on behalf of the respondents. Respondent numbers 1 to 5 in both the appeals. Both the appeals are directed against the common judgment and decree. Dated 1/8/2024, passed by the learned civil judge, senior division Lokhimpur at North Lokhimpur, entitled appeal number by the learned civil judge, senior division Lokhimpur, North Lokhimpur, hereinafter for short referred to as the learned trial first appellate court, entitled appeal number 4/2024. There's one appeal, na?
What's one?
Thereby confirming the judgment and decree dated 4/1/2024, passed by the learned civil judge, junior division number 1, Tejpur. Tejpur, why?
That time it's from Kimpul.
Huh? Lokhimpur, na? The one Lokhimpur at North Lokhimpur, hereinafter referred to as the learned trial court in title suit number 39/2019. Both the appeals are take next. Both the appeals arise out of the common judgment, arise out of one suit arise out of title suit number 39/2019 and challenges the judgment and decree dated 1/8/2024 passed by the learned first appellate court. Both the appeals are taken up together to ascertain as to whether any substantial question of law can be formulated in terms with section 100 (4) of the Code of Civil Procedure 1908, or short, the Code. For the purpose of ascertaining the said aspect, this court finds it relevant to take note of the facts which led to the filing of the instant appeal, filing of the present appeals. For the sake of convenience, the parties herein are referred to in the same status as they stood before the learned trial court. The respondents herein, as plaintiffs, had filed a suit before the learned trial court, which was registered and numbered as title suit number 39 of 2019, seeking declaration of their right, title, and interest over the suit land. As described in the plain, along with recovery of khas possession, semicolon, for a decree for cancellation of the mutation of the defendants, as well as for permanent injunction. The brief facts which led to the case of the plaintiffs in the suit was that a plot of land at measuring 7 bighas, 0 katha, 4 lechas was the ancestral property of the plaintiffs. Once Simon Orang, SIMON, who was the father of the plaintiff number 1 and the grandfather of the plaintiff numbers 2, 3, 4, and 5, was the patadar of the said land. After the death of Simon Orang, the name of the plaintiff and the names of the plaintiffs were mutated. On 4/4/2013, the names of the defendant number 1 was mutated by the circle officer Novosia over a plot of land at measuring 1 bigha, 2 katha, 10 lechas. Which is the part of the land, the ancestral property of the plaintiffs, which at measure 7 bigha, 0 katha, 4 lechas. It has also been alleged that on 17/7/2013, the defendant number 2's name was also mutated against another plot of land at measuring 4 bigha, 4 katha, 4 lechas. 4 bigha, 4 katha, 4 lechas. This land, which was also mutated in the name of the defendant number 2, was a part of the ancestral land belonging to the plaintiffs. The plaintiffs who were It is at this stage, it is very pertinent to mention that the land in question fell within the tribal belt. And then as constituted by the state government in terms with chapter 10 of the Assam Land and Revenue Regulation 1886. Which, taking into account that the mutation was carried out behind the back of the plaintiffs as alleged, the plaintiffs filed a revenue appeal number 4/2015. But as the plaintiffs were not satisfied with the finding and with the outcome of the said appeal, the suit was filed. It was also alleged in the plaintiff in the plaint that the plaintiff had also filed a miscase number 127/2014 under section 107/145 of the CRPC, Code of Criminal Procedure 1973, for short, the CRPC, before the court of the additional district magistrate. But the prayer so made in the said application was rejected by an order dated 28/9/2018. It was also alleged that the plaintiffs paid land revenue over the suit land till 2013. And since then, the Mojada refused to accept payment of land revenue from the plaintiffs. It is under such circumstances the plaintiff have sought for the reliefs as already mentioned herein above. The defendants filed their written statement joint, na? Filed their joint written statement in the said written statement. It was alleged that the father of the plaintiff number 3, 4, and 5, namely one Atmasius, Atmasius, Orang, who was the Patada during his lifetime, sold his share of the suit land sold his share, which is the suit land, to the defendant number 1. And the defendant number 2, and handed over the possession. It was further mentioned that the said Atmasias Orang also signed the Chitta book. And in 2013, the name of the defendants were mutated over the suit land. It was also mentioned that more than 3 years have passed since the date of mutation, and the right title and interest of the defendants is therefore proved. At paragraph number 5, it was also mentioned that the father of the plaintiff number 3, 4, and 5 had handed over the possession to the defendants and signed the chitta. And as such, the defendants have right title and possession over the suit land. It was also mentioned at paragraph number 6 that the plaintiffs had filed RA number 4/2015 and 5/2015, but did not take any steps to prosecute the same, and hence they were dismissed. At paragraph number 7, it was mentioned that the proceedings under section 145 were dismissed on the ground that the plaintiffs could not prove their possession. It was also mentioned that in the said proceedings, it was held that the defendants were in possession of the suit land since 20 years. Paragraph number 8 of the written statement, it was further mentioned that the suit land being a tribal land belonging, the suit land being a land falling within the chapter 10 of the Assam Land and Revenue Regulation 6. बोलते अपने land and regulation of the regulation. The suit was barred, the civil court's jurisdiction was barred. On the basis of the pleadings, the learned trial court framed 6 issues which are reproduced herein under page 43. During the trial, the plaintiff adduced the evidence of 6 witnesses and exhibited the various documents. On behalf of the defendants, 5 witnesses were examined and various documents were also exhibited. The limit trial court. After dealing with the evidence on record, came to a finding. Now, passed a judgment and decree on 4/1/2024, declaring that the plaintiffs have right, title, and interest over the suit land. Semicolon. The plaintiffs are entitled to recover the class possession over the suit land by evicting the defendants. Semicolon. The mutation of the names of the defendants over the suit land was held to be illegal and liable to be cancelled. And further, the plaintiff was also granted a decree for permanent injunction as was sought for. Being aggrieved, the appellants hearing, who were the defendant numbers 1 and 2, preferred one appeal, na? Preferred an appeal, being titled appeal number 4/2024. Before the learned first appellate court. The learned first appellate court, by the judgment and decree dated 1/8/2024, decreed the suit, dismissed the appeal, and confirmed the judgment and decree passed by the learned trial court. It is under such circumstances, the defendant numbers 1 and 2 have filed these two separate appeals by invoking the jurisdiction under section 100 of the code, being RSA number. Which one is what? Which Ayesha Khatun is who?
Asya Khatun is RSA 220.
Is defendant number 2.
She is the defendant number 1. And then
Being
number
RSA number 220 of the 2024 and RSA number 216 oblique 24 oblique 2024 respectively. In the backdrop of the above, this court finds it relevant to take note of whether substantial questions of law. Eight.
page 8.
Finds it value that in the both the appeals, identical questions of law have been stated to be substantial questions of law involved in the appeals. The said questions of law so proposed in the memo of appeal are reproduced herein under page 18 of the addition number 20. The question which arises is as to whether these questions of law so proposed can at all be formulated as substantial questions of law in terms with section 100 bracket 4 of the code. For appreciating the same, this court finds it relevant to take note of the submission made by Mr. A. Ganguly, the learned counsel appearing on behalf of the appellants in both the appeals. Mr. Ganguly had submitted that the materials on record would show that the plaintiffs have also admitted in their evidence that the defendants were in possession of the suit land for a period of 20 years. And as such, the possession of the defendants are required to be taken as adverse to the owner, to adverse to the plaintiffs, as well as their predecessor, which both the courts failed to take into account. He further submitted that in a suit filed for based upon title, along with the reliefs for possession, the plaintiff is required to prove when the plaintiff was dispossessed. And in absence thereof, the plaintiff cannot be, no decree can be declared, granted in favor of the plaintiff for recovery of possession. Additionally, Mr. Ganguly further submitted that the plaintiff a perusal of the plaintiff would show that there is no compliance to the provisions of Order 7, Rule 1E, isn't it? And as such, the suit would not have been at all decreed in favor of the plaintiffs. Let this court now take up, in view of the state submissions duly recorded. Yes, you want to say something? Let this court, therefore, now in view of the said submissions, let this court now consider as to whether, on the basis of the said submissions so made by the learned counsel appearing on behalf of the appellants, the substantial questions of law, the questions of law so proposed can be formulated. The first question so proposed pertains to whether the courts below had committed gross error of law in failing to consider that the appellants were in continuous adverse possession of the suit land since the last 20 years. This court, in the previous segments of the instant judgment, have duly taken note of. The pleadings of the defendants who are the appellants herein. In the said pleadings, in the written statement filed by the defendants, there's not a single whisper as to when the defendants claimed that the possession had become adverse to the plaintiffs or their predecessor in interests. It is a tried principle of law is a tried principle of law, as would be seen from the judgment of the Supreme Court in the case of T. Anjanappa versus Tomalingappa, reported in 2006, 7 SCC 570. That mere possession, however long it may be, does not necessarily mean that it is adverse to the true owner. And the classical requirement of acquisition of title by adverse possession is that such possession are in denial of the true owner's title. The Supreme Court in the case of Chatik Konati Rao versus Pale Venkata Subbarao, reported in 2010, 14 SCC 316, further detailed out what are the requirements of claiming adverse possession. Paragraph 14 of the said judgment, being relevant, is reproduced hereunder. In the backdrop of the above, the question therefore arises in the backdrop of the above. It is very pertinent to take note of that merely because of the possession, that merely because the plaintiff admits that the defendants are in possession of the suit property for the last 20 years would not cannot be considered that the possession of the defendants are adverse to the plaintiffs or even their predecessor in interest. This court further finds it relevant to take note of that in the pleadings of the defendants, there is nothing mentioned. Not only there is nothing mentioned as to when their possession had become adverse, but on the other hand, it is seen that the defendants have claimed title through the plaintiffs as well as through the predecessor in interest of the plaintiff numbers 3, 4, and 5. As would be apparent from a perusal of paragraph number 4 and paragraph number 6. In the case of government of Kerala and another versus Joseph and others reported in 2023 17 SCC 400. In the case of Anna Saheb, Bapu Saheb, Patil versus Balwant, reported in 1995 2 SCC 543. The Supreme Court categorically observed that a claim of independent title and adverse possession at the same time amounts to contradictory pleas. It was observed that when the possession can be referred to a lawful title, it will not be considered to be adverse. And the reason being that a person whose possession can be referred to a lawful title will not be permitted to show that his possession was hostile to another title. It was also observed that when a person enters into possession having a lawful title, cannot divest another of that title by pretending that he had no title at all. In the instant case, a perusal of the pleadings could show that the plaintiffs, that the defendants had claimed the rights on the basis of that the rights on the basis that the land had been sold by the predecessor of the plaintiff number 3, 4, and 5 in favor of the defendants. However, no such deed of sale was exhibited. It is, however, very interesting to take note of that there was a Chita mutation done in the year 2013 on the basis of the plaintiff, on the basis that the predecessor of the plaintiff number 3, 4, and 5 had signed in the before the revenue authorities in the Chita book. It is relevant to take note of that the suit was filed in the year 2019 and the Chita mutation was done in the year 2013. So under such circumstances, till 2013, the plaintiff defendants had duly acknowledged that the plaintiffs as well as the plaintiff's predecessor in interest had the title over the land. And as such, the question of adverse possession, and as such, the question of law so proposed as regards adverse possession that the plaintiff defendants had adverse possession merely on the basis that they had possession over 20 years cannot be framed as a substantial question of law in terms with section 100, bracket 4 of the code. Well, again, I'm not finding it. Page 7, page 8, page 9. Then where is your substantial question of law?
Page 8.
Page 8 is different, na? How many page 8s you have?
Page 8 will have these three.
Huh?
These three questions are at page 8.
This is what I'm not finding. Page 8 is there. You have a serious problem with pagination, huh? Morning also. क्या बोलेंगे? कहने को बोलेंगे। Necessarily.
Page 8.
Huh?
Page 8.
Both the happens page 8. So it was
Understood, but page 8 is this. See page 8. This is page 8. He has a serious problem, Mr. Ganguly. Take your office properly. Happy is too love it.
go back to the- perhaps yes. In the front part, the amended memos, not in the back. It was filed and then amended. Yes.
Take Marijo. The second question so formulated. Pertains to as to whether the appellants, whether the plaintiffs were stopped from claiming their right, title, and interest over the suit land. On the basis that late, on the basis that they admitted in the play, they admitted during the cross-examination that late Atamayas Orang had himself delivered possession of the suit land to the appellants, to the defendants. You see, the rights, title, and ownership of an immovable property rests upon a person on the basis of the title in this court have duly considered that in order to vest a title over a property to another person, over an immovable property to another person, such vesting has to be within the confines of law. In the instant case, the defendants claimed that late Atamias Orang had sold the land to them. However, there was no documents produced to substantiate the same. The land in question is situated in an area where both the Transfer of Property Act 1882 and the Registration Act 1908 duly applies. Under such circumstances, the transfer or vesting of the title upon the defendants has to be in a manner recognized by law. Merely delivering a possession of the suit land by late Atamias Orang would not confer any right upon the defendants to have ownership over the suit property, in as much as the title over the suit property continues to remain with the plaintiffs pursuant to the death of their predecessor in interest. Under such circumstances, the second question of law, so proposed to be substantial question of law, cannot be formulated as a substantial question of law involved in the instant appeals. The third question, so proposed to be a substantial question of law, pertains to as to whether the suit seeking recovery of possession was barred by the laws of limitation in view of the stand that the defendants were in possession of the suit land since the last 20 years. As already mentioned while dealing with the first question of law, so proposed. However long the possession may be, it does not convert into adverse possession unless and until it is pleaded and proved in accordance with law. Under such circumstances, the third question of law, so proposed in the memo of appeal cannot also be considered as a cannot also be formulated as a substantial question of law involved in the instant appeals. This court further finds it relevant to take note of. In addition to that, this court also finds it relevant to take note of the submissions so made by Mr. Ganguly to the effect that the plaintiffs, having not stated in the plaint, not pleaded and proved as to when they were dispossessed, the plaintiffs were not entitled to recovery of possession, not entitled to a decree in the suit. The said submission in the opinion of this court is totally misconceived, inasmuch as in a suit based upon title, for recovery of possession, once the title based on title for recovery of possession has two parts. First, adjudication on the question of title, and secondly, once the title is being proved, the said suit takes the color of an ejectment suit. Once the suit takes the color of an ejectment suit, it is for the defendant to prove that he has a better right to remain in possession of the suit property. In this regard, this court finds it relevant to take note of a judgment of the Supreme Court in the case of Indira versus Arumugam, reported in 1998, 1 SCC 614, wherein the Supreme Court observed that when a suit is based on title for possession, once the title is established on the basis of relevant documents and other evidence, unless the defendant proves adverse possession for the prescriptive period, the plaintiff cannot be non-suited. This court further finds it relevant to take note of the judgment of the Supreme Court in the case of Maria Margarida Securia Fernandez versus Erasmo Jack Securia, reported in 2012 5 SCC. (370), wherein the Supreme Court categorically observed at paragraph number, categorically observed that in an action for recovery or possession of an immovable property or for protecting possession thereof, upon the legal title to the property being established, the possession or occupation of the property by a person other than the holder of legal title will be presumed to be under and is subordinate and in subordination to the legal title. And it will be for the person resisting a claim for recovery of possession or claiming a right to continue in possession to establish that he has such a right. Full stop. Paragraph number 64, 65, 66, and 67 of the said judgment being relevant is reproduced hereunder. Full stop. Taking into account the above propositions of law, it is therefore the opinion of this court that the said submissions so made by the learned counsel appearing on behalf of the petitioner appellant is totally misconceived. Lastly, this court finds it relevant to take note of the submission made by the learned counsel appearing on behalf of the appellant that the claim is not in accordance with, have not been drawn up in accordance with Order 7, Rule 1, bracket E of the code of the code. This court finds it relevant to take note of that no objections were raised at the trial in the written statement or even in the trial as regards the deficiency in the plaint being not in compliance with Order 7, Rule 11, Order 1, Order 7, Rule 1, bracket E. In this regard, this court finds it very pertinent to take note of the judgment of the Supreme Court in the case of Santosh Hazare versus Purushottam Tiwari, reported in 2001 3 SCC 179, wherein the Supreme Court categorically observed at paragraph number 14, that to be a question of law involved in the case, there must be first a foundation for it laid in the pleadings, and the question should emerge from the sustainable findings of fact arrived at by the courts of facts, and it must be necessary to decide that question of law for a just and proper decision of the case. It was further observed that an entirely new point raised for the first time before the High Court is not a question involved in the case unless it goes to the root of the matter. Paragraph 14 of the said judgment being relevant is reproduced hereunder. In that view of the matter, the said contentions so raised as regards the deficiency in the claim in respect to as regards non-compliance with Order 7, Rule 1E cannot be formulated as a substantial question of law involved in the instant appeal. Because considering the above, this court does not find that there any substantial question of law that can be formulated in the instant appeals for which both the appeal stands dismissed. However, in the peculiar facts of the case, this court is not inclined to impose any costs.
Because, I think that we had paper, some of that. Still fun.
Huh?
That
What?
is all the second one. I mean, that's what should make reconsider that part.
I've heard it, but this is the manner here also. This is the
Even
problem.
the amended memo is there, and the other matter.
The claim means you are not to file your amended appeal. How can you file an amended appeal? Tell me.
That was the order passed by a different coordinate bench. Pursuant to that, we have,
File an amended appeal.
as far as item one is concerned, we want you to kindly reconsider.
You are to file. You have taken this type of prayers. Current praise to enable him to file an amended memo of it. You say,
That amended memo, and that is based on the, as far as item one is concerned, I.
I send the LCR back. This one. It is that little last one. It is seen that although the appeal have not yet been admitted, but inadvertently the records the records of the courts below were called for. The race we shall return the reports. Yes, what do you have?
Item one, what you. Reconsider.
Raise your friend.
I will inform him.
When do you want it?
But if possible, Thursday or next Tuesday, subject, any date,
You missed your break. Huh?
any date.
I was supposed to dispose it of. And this is how you.
No, Lordship has brought it this far,
Huh?
Lordships have brought it that far, because that substantial question of law was only on that aspect. I'll provide the copies to you. Any date, I'll,
Item number one to Laker, Mr. Ganguly submits that proper copies which tally with the records of the instant appeal would be provided to Mr. N. Hawk within 2 days. This is taking into account the above, this appeal for hearing on 13th of May 2025.
If this matter, this whole petitioner has expired last 20th.
Hmm?
The petitioner has expired. So, my lord, the legal is to be substituted. Next time maybe. That's a bit weird, so, my lord. The petitioner also appeared, my lord. Was not dispute like that.
Tell me the people.
Mr. Chakravarti, his name is not be displayed.
Is that?
Because of Chakrabarti being not there, you stay for another 3, 4.
No, madam. I'll substitute, madam, within 3 weeks, madam. Because tomorrow is the petitioner, madam. Petitioner is expired, madam.
Who ex-
Petitioner, I put a petitioner. Last 20th, madam,
When did he expire?
on 20th April, madam, 25.
41.
Our legal aid is to substitute him.
Huh?
Legal aid is to substitute him, madam.
So why haven't you substituted?
No, madam, just 10 days is one, madam.
So?
The son is in bereavement, madam. He has to come and,
You have the names of the legal heirs?
one name is there, madam. One son is there, madam.
So give it to me. I'll substitute. Give it to me.
Only one son name is, madam, I've been informed that, that is Vijay Kumar now.
Okay, you substitute. So,
But I don't know whether he has other affiliates or not.
not necessary.
Whether
Not necessary. One is enough.
one is,
Because here, when it comes to landlord-tenant relationship,
yes,
only one person is enough.
Sudip Kumar Nath, son of late Harendra Kumar Nath.
Yes. We do one thing. Let us keep it next week. You get all whatever the names are there. Then we are going to increase it.
That's,
File an affidavit.
that,
File an affidavit that we. Because in view of the recent judgment of the Supreme Court in 2025 SCC 9 SC 91, once it is brought to the attention of the court will do it. Because either party can file it. It is not that it is only that person concerned has to file.
yes, sir.
So otherwise it will be only a delay. And only one also, it is only the question because this is
Landlord tenants are money, one will suffice. One will suffice money.
one is surprise, there is not requirement of many. Because of the fact that in a landlord tenant dispute, if it is a tenant, it is held to be tenants in common. So there is no requirement of everybody. If the tenants in common will be
Yes, yes.
one will. Mr. So-and-so, as not the learned counsel appearing on behalf of the petitioner, submits, learned counsel submits that in, ESNA submits that in terms with order 22 root any. Of the code of civil procedure 1908, the petitioner had expired on 24/2025. He therefore submits that he will file an affidavit by next week. Bringing the notice of this court, the legal representative filing an affidavit of the application next week, bringing to the notice of this court. Legal representatives of the petition. This matter again on 15th of May 2025 at 2 p.m. To stop the application public affidavit be filed on or before 9th of May. To stop the interim order passed earlier shall continue to. None appears on behalf of those.
For hearing item 12 and 13.
Tell me. Whether the government would be a necessary party.
Understanding it, government is a necessary party.
Why?
Because of the fact that they have asked for a declaration that the order passed by the ADC. to be modified. And second question on the.
No, because the property does not belong to the government.
Yes,
There I was looking through the temporarily settled area tenancy act 1971.
correct.
If it is a land of the government, that act is not applicable. But if it is not the land of the government, then it can be done. Okay. So therefore, the government is creating rights in your favor on the basis of the act. Okay. So it is inter se a dispute between you and the plaintiffs.
The middle of the dispute of both the parties, private persons. The government has acted, the ADC has acted in view of the 71 Act.
Huh?
The government, ADC has acted in view of the 71 Act.
Understood. 71 Act, the regulatory act by which the government has done so in terms of section 23. Had given you the ownership and also given you the Khutian. Now the Khutian is exhibited.
Yes.
Now, question is,
Because Khatian was not included, Jamabandi was.
no, Jamabandi will not do it. Now, Sukiani is not exhibited. If the Sukiani is not exhibited, then how did you show that you had the right under 21?
The order passed by the ABC was it.
Understood, that is an order passed.
So subsequent order, where after payment of this premium, it was.
Everything is that is understood. So that is an adjudicatory order. So if it is an adjudicatory order, that officer cannot be made a party. Now the question is, I was just thinking, in respect to a land belonging to the plaintiffs, wherein rights have been granted to you by operation of by distributions of law. Whether the state is a party. Maybe a proper party. Maybe a proper party. But is it a necessary party? Because you see, just for example, let us assume that about now, the decree is set aside. A decree is allowed. The decree did not affect the state. Correct. Could only affect you. Therefore, let us take the case of some fixation of land ceiling. Once it becomes a ceiling law, it goes to the government. And the government then gives it to you. So it is a government property which is being given to you. In terms of 16 or 17, whatever you mean, the fixation. But here, the government does not get any right anywhere over the land. Then under such circumstances, how will the government be a part? But it may be a proper but necessary.
Perhaps, their understanding perhaps because of the fact that the fair scene.
You have referred to that day a judgment. '99, na? Oh, not 99 years ago. Indeed. Now, you referred to one judgment now, what is that? One is, it goes to the root of the matter, then it can be paid. Another judgment,
And 2022 SCC online 650. SCC.
gave it to me that day.
There are 33.
Clause as well as the subsequent both mandate that the actions of the necessary party, the order passed. There is no quarrel with that proposition we are referring to. But refer to is the, in respect to these matters also, state is required to be made a party. Is a necessary party, not a proper. A party concept is not there, but then also the necessary party. Because this has relevance. Because while I was going through the entire Act of 1971, I could not find. First, the land is not the government's. Government is this border. Whether you get the ownership or he gets the ownership. You have a right, claim ownership. Now, we see section 68. The temporary settle year 1971. In the landlord tenant dispute, it is the civil court who also. Okay. Now, if the plaintiff is saying that you were never my tenant, it would not come on the chapter 10, preparation of the records. It would come on the landlord tenant dispute, whether you were there. So therefore, the civil court has the jurisdiction. Now, if the civil court has the jurisdiction, and the civil court says that there was no landlord-tenant relationship, then the order which has been passed by the APC or whatever, it becomes without jurisdiction, without the landlord-tenant relationship. So, how to take care that it is a necessary party? If it is not a necessary party, the appeal goes. So it is only on that thread the appeal is there, because the other questions of law don't use. I'll have it again another day so that you prepare it. Because of the fact that this is the new thing, because I was all along holding that the necessary party. But that day I was just going through, more particularly the judgment of Justice Wangshu. And it comes up with a very interesting aspect. The fact that if the property is of the government, then it's a good thing. And the government is a necessary party because it will be affected. But the property here is not of the government. And the government, if it is the government property, then there is an exception. By exception, Act of 71 does not. Okay. So you look into that. Now, that is one side. Now, if I hold it, yes, it is a necessary party. And I say that, okay, the state has to be made a party. Then if I allow you to make a party, there's again a problem under Section 80. How do you take care of that situation? Unless this court have to make them a party and waive 82. This court has to. Because there the court cannot do. Or there are two options. One is this court waiving 82, making the state a party and remanding it. The second is this court gives you opportunity to remand it back, giving you opportunity for 2 months, give that notice, and thereupon file an application. Which I think is not possible, taking into account that would amount to, that would be a bit more complicated issue. Because the state, without Section 80 compliance or 82, making state the Supreme Court. Because if I make them a party also, tomorrow they are going to raise that issue on compliance of 80. And for that, your suit will go again. So it will not be effective unless I make it the state a party and waive 82, then proceed. This is the other way. You have to first necessary part. If it is a proper party, you have no case. But if it has to be a necessary, it is not. It is not done.
That is what the Rajasthan court, like the very monsoon then.
So I was just looking into it. That if it is a government land, obviously. Because the government is going to.
Yes, not definitely, then,
But it is a interstate dispute between A and B.
precise.
And thereby B is being conveyed a right. And this act is a regulatory act by which certain rights are being conferred. And where is the property?
Properties of. Corporate is, village Raipur, Bozar. Town. Bozar,
Town,
then town. Bozar town.
within town. Then how Khatian was issued?
No, we've been alleging all along. That there is never a tenant.
How Khatian can be issued in view of the are
Definition of town.
contained in the.
That is,
The town lands is an exception.
exception after this. Perhaps that time it was not a town land. At present, it is.
At that point of time, it would not come under any municipal. Municipal corporation.
Now it's under a town.
When it was made town,
That instruction I have to get.
find it out. He is the petitioner in first. Thank you.
How much you bother again?
So it was in 2000. And when was the Khatian given?
2003.
2003. Ownership was given of Khatian.
Ownership was given. Ownership was given. Hotiyan whether they did not exhibit the Hotiyan.
If it, Khatian is not there. And what does it say about that order? The order there must be mentioned.
Yes, madam. I'm just reading it. It's an order dated 15/5/2003 that was executed.
So it has to be after 3 years, after 1 or 3 years. A person who has an occupancy tenant for 3 years, then only he can claim 21.
Yes, then there is no dispute regarding. Because otherwise notice was also issued. It was done. All the
But
orders,
why the opinion was not exhibited at any point of time? Who did the fundamental for 2001 document for claiming your basis of your order? We'll have it when next week. We need to finish it off. 2014 matter. The third. We need to find out that because there things are very important aspect. But I have to categorically hold one thing. It is not required to make the state a party. Even when the orders are being challenged. Even when the orders are being challenged, because I have framed that issue.
Yes.
I have to make a, when the state is not required to be made a part, then when the order is being passed, then it does not belong to. So the government is not going to be affected. That's not bothered. His right is only one. And his right is curtailed on the basis of a landlord tenant relationship.
Which our High Court has said exclusively civil court will decide.
You need high court.
Otherwise. 68 is.
You heard the matter further. And taking into account that the land wherein the order have been passed, granting ownership rights to the appellant, which have been set aside by the learned, by both the courts below, are not government lands. This court would further hear the parties as to whether the government of Assam as well as its, as well as the officer would be a necessary party to the present, necessary party in the suit. This the matter again on sixth possible. Thirteen. 13 at 2 p.m. Hey, good, very good.
Item 14.
Yes,
I'm responding. Arla? Arla appeared. His name is.
it's Buragoy. He was here very much. I saw him here. Probate,
COVID was granted.
there is a stay. They challenged it. Who are they? Who is the appellant?
Simply. His brother.
Okay, why were the property given to you,
I looked after mother.
your mother? He challenged the document.
Kelly,
Ah,
signature is not disputed. Although he says that. Second.
more fabricated, but in the pleading as well as in the evidence, it is mentioned.
What is your name? Anipia. Okay, therefore I'm saying each Puragai appears for a respondent, okay. So, yeah. So we dismissed. Earlier also, none appeared on 13/3/2025. None appears on behalf of the appellant on call. Pusto. It is seen, Mr. D. Mojumdar, the learned senior counsel assisted by Mr. S. Biswas, appears on behalf of the respondent. So it is seen that on the earlier occasion also, that is on 13/3/2025, none had appeared on behalf of the appellant. Considering the above, court is of the opinion that in considering the above, it appears that the appellant have lost interest in the instant proceeding for which the instant appeal stands dismissed. Issue. For the arrangement shall return the LCR after 90 days from the date of the instant order. Contain orders if any instant vacated.
Item 15.
Which one? Item?
15.
Whether Dhoni and subsequent to the acquired good title to the share of the property of the donor who are making a guarantee with the party that void to them. There is a code below are right in the decree. In the should be done. Yes, none appears for the appellant. Dismiss it for default. Yes,
Thursday lottery already.
no. 4:45 we can, I think the judgment can be.
Matter will take.
Huh?
This matter will take.
No. Second appeal doesn't fix. Somebody told me when the suit comes and reaches the stage of second appeal, it is already worn out. Nothing remains. So we are waiting.
But for current finding of fact,
And he has further reduced the. Yes, tell me.
Lordship, the respondent filed the title suit lordship with the declaration. For declaration of title over the suit like recovery of possession from the, from the defendant. The fact of the case is this, lordship, that the plaintiffs and the defendants possessors interest were the owners of the plot of land beginning for cutter. Lordship and the plain. May I read the plaintiff?
Not
Paragraph
necessary. Tell me the facts. What is there? Why do you need to read the plain? So if we are in the second appeal, what is your question of law? The question of law is twofold. What are these? Let us see. Two questions of law.
substantial question of law.
Whether Dhoni and the subsequent transferee acquires good title to the share of the property of the donor, the owner, making a gift which is partly adjudged void to the extent of the share of the other owners. Whether the court below are right in decreeing the suit without a decree for partition.
It is the pleaded case of the both the parties lordship that the suit land was a joint property.
4 kathas of land.
Yes, 4 kathas of land.
4 kathas of land. 2 kathas belong to Umesh Das and 2 kathas belong to Kamal Das. Okay. Now Kamal Das executed a gift deed in favor of the defendant number 1.
In favor of defendant number
1. Defendant number 1 dated 29 181 1981, thereby giving 1 katha 16 letters. Isn't it?
Yes, yes.
Thereby giving 1 katha 16 letters
16 land. Yes.
to the defendant number 1. Isn't it? Defendant number 1. Okay.
With
Out
this-
of his 2 kathas he has given. Out
yes,
of his
out
2
of two
kathas.
kathas.
yes.
Both were in joint possession.
I can take one.
Joint property.
Yes, yes, please.
That is not.
Just one. 4 cutters of land, brothers. Kamal Das and Umesh Das. Now, Kamal Das had 5 legal years.
Yes. Then
Defendant number 1 and perform defendant number
number 1.
and perform defendant 2 to 5. These are all entities.
Okay. These are Kamal Das, na?
Kamal Das.
P1 and P5. Okay, then
Now, the other brother, Umesh Das, also equally had 5 legal years.
P1 to 5.
P1 to 4 and
And D2. Then
now, Kamal Das who had right over half of it, there is 2 cutters. gives the entire land by way of a gift to his son D1.
How much? 4 kathas.
Based on that gift deed,
So this gift deed is for 4 kathas.
yes, God statement did not go to anything else. In the written statement, they have admitted the entire position. Right? Just one paragraph in the written statement, last paragraph, the entire story is given and an admission. Nothing else is required to be seen. Page 22.
Executed a year by 4 kathas.
Yes.
The Sutag in favor of Bimal Das. Who is
Yes.
Bimal Das?
Bimbo Das is D1, number one.
D1.
Yes.
Okay. Then what does he do?
Then on 28/3/1985,
Yeah.
defendant number one and that defendant number two of Umesh Das executes a sale deed in favor of defendant number two for 2 kathas.
One and D2. D1 and D2.
D2 was not required. Story in the statement is since D2's predecessor's name is there in the revenue record,
Okay. So D1 and D2 executes for how much land?
Cut.
2 katha to
defendant number one and defendant number four.
D4.
Now, on 10/89, subsequently, defendant number sold 1 katha 60 paisa to defendant number 3.
D1 again sold.
Yes.
1 katha
No, defendant
16.
number 4.
Huh?
The purchaser, defendant number 4, he sells to defendant number 3.
Out of that 2 katha.
Yes.
He sells it to defend number
3,
D3.
who is now contesting. He has constructed house over the land. He is
Okay. So
contesting.
D4 sells it to D3.
Yes, 1 katha 16 lesser.
Okay.
Subsequently, another sale is 7/3/89. Even defendant number 4 sells 2 katha 4 lesser to defendant number 3.
Again another.
Yes. So
2
altogether,
katha.
katha 4 lesser.
Two
So
less.
altogether, defendant number 3 becomes owner of 4 kathas. Entire land belonging to 2 brothers.
So defend number 3 is now the owner
Yes.
by dint of 10/2/89 and 7/3/89.
Right.
And this is on the basis of a gift of 29/1/1981.
Different dates are given.
21/9.
Yes. In one place, they have mentioned 69, but it's
21/9 to the 1981. He has given a gift of 4 kathas to D1.
Right.
So the entire subkatha.
Yes.
Okay. So
Now-
there he gives it this much and then from there. Now plaintiff Umesh Das.
I'm coming. Plaintiff 1 to 4, who are the legal heir of Umesh Das,
uh,
they are.
No, just 1 minute, just 1 minute.
Fine.
D1 and D2 by the deed of sale
Fine.
dated 28/3/1988,
85.
85, sold how much land?
2 katha.
2 katha to D4.
Yes.
Then D4, how did D4 sell 4 kathas?
It will for them to answer. There is no answer. Yeah. A very clumsy judge. I'm just giving very simple explanation.
So D4 sells it to D3, 1 katha. So, okay, 2 out of 2 kathas, he sells it 1 katha 16 lecha.
16 days. And
But
on 7/3/89, D4 again sells katha 4 lesser. So now altogether, defendant number 3 becomes owner of 4 katha. 1 katha 16 lesser plus 2 katha 4 lesser.
So admittedly, there is no partition.
Now there is part. I'll come.
When?
There is no party.
Okay, then
Now lots of can see Umesh Das's legal heir, sorry,
P1 to
P4,
P4.
P4 are the plaintiffs.
Hmm.
They say that P2 is the fifth legal heir of Umesh Das. Is entitled to 8 lectures out of katha 40 lectures divided by 5,
Hmm.
8 lectures each.
Yes.
Now, excluding the 8 lectures, remaining plaintiffs are entitled to 1 kata 12 acres.
1/12. Yes.
Clear? Now they have filed, because the entire land is in the hand of appellant,
D3.
the 4 kata. So nobody is saying that I am in possession, there is no partition. Now plaintiffs number 1 to 4 who are entitled to the remaining 1 kata 12 acres. The rest they are not claiming, others are not opposing. So there is no partition is required by law. They have filed the suit, paying for declaration of prior recovery of possession and declaration that the gift is bad. Trial court has found that yes, if it could not have been executed for more than 2 katas by Kamal Das or Vivar Hussain Vimal Das. Therefore, for the remaining part of the land, it is bad. That is why they have framed the question that it has been adjudged partially void. That is the reason.
So, in terms with 44,
Fine.
44, a co-sharer can only sell his saleable interest.
Exactly.
So if his saleable interest is only for 2 katas, or if only 2 katas, he cannot execute more than 4 katas. So the gift deed insofar as selling 4 katas is bad, the gifting 4 katas is bad, but 2 katas is okay.
I need not raise an objection.
Okay. Now, so that is 2 katas. So D1 does that. Now what about D2? The D2 sell it to D1,
That will be very
Is
strict
2
with the main
kata.
features.
2 katas.
Uh-huh.
2 kata in 85,
Right.
which means D2's at best share is 8 lesser. So his share will be 1 kata 12 lesser.
D-
D1's out of that 4 katas,
Yes, ma'am. Exactly.
isn't it?
Yes.
So D1 still has 8 lessers,
His own share.
his own land, 8 lessers. So D1 retains 8 lessers. Because D2 sells his only portion is 8 lesser. Okay. Now, D4 sells 1 katha 16 lecha from the 2 kathas.
Yeah.
And again sells 2 katha 4 lechas. Okay, he can sell at best another 2 kathas. So he can sell it these 2 kathas. And then the remaining 2 kathas sold to the D3 is wrong. That's it.
And these, they have admitted also, trial court and the prosecutor ought not to have gone into all these things. And prosecutor kindly have a look at page 28, Choi. He admits,
Page
page 22.
22.
Fine.
Yes.
That on 21/9/81, Kamal Das executed a registered gift deed in respect of 4 katas of land in favor of Vimal Das and divested himself of all his right and interest, and Vimal Das acquired full title thereto. Even if it is assumed that within 4 katas of land, he had title over 2 katas, that is half share. In that case, Kamal Das was legally entitled to make a gift in respect of the same. Correct. In case of Kamal Das and Umesh Das, the Jayabaka School of Hindu Law is applicable. Kamal Das legally was entitled to gift the said 2 katas for the reason that after that gift, Vimal Das had 2 katas of land in his share. Therefore, he is entitled to 2 katas of land and was able to sell the same to defendant number 4. Even if it is assumed that Umesh Das had title Das, according to the admission of the plaintiff, the defendant number 2, Bhaven Das, had at least entitled to 10 letters of land. In place of 10, it will be actually 8 letters of land, I'm saying. Therefore, they were entitled to sell 2 katas, 10 letters of land out of the entire 10 katas to defendant number 4, Bhaven Kolita, as they had title there too. Hence, out of 4 katas, defendant number 4, Bhaven Kalita got title to 2 katas, 10 letters of land. Therefore, the defendant number 4, Bhaven Kalita, was entitled to sell 1 kata of land to number 3. The defendant number 3 purchased the same for valuable concession from Bhaven Kalita and he acquired title. After taking over possession, he is possessing the same in his own right by constructing house. Defendant number 3 is a bona fide purchaser for value without notice and therefore he is protected and safety for he is admitting the whole thing.
But what about the remaining 2 kathas? Which have been sold by 7/3/1989.
That's what I'm saying, my lord.
Where is it mentioned?
No, they are saying that by virtue of the gift deed, Kamal Das' son, Vimal Das gets 2 kathas.
Okay.
Now-
He one gets, he one by gifty can be only two kathas.
But
can be-
now from Umid Das' share, since different number 2, there is the fifth legal heir of Umid Das is going in favor of the present appellant.
So both
These
D1
ledgers
and
will go
D1 and D2 had two katha, 8 lectures
together,
together.
D1 and D2. Yes, 2 katha, 8 lectures, exactly.
And these they can part with and give it to D4, but D4 was initially sold only two kathas.
Right.
So therefore D1 being retained 8 lectures. So he has only 8 lectures. But how did D4 sell to D3 another two katha 4 lectures? Yes, 4 lectures he can, but how can he sell the two katha?
I know that
Has the
is not-
sale deed been challenged? You have set aside that. What does the trial court do? It is declaring the right title and in case of a plaintiff over describing by confirm and the sale deed dated 23 is declared void. And in when the plaintiff is then by evicting the defendant by demolishing the houses standing. But how is this possible, this order? Recovery of possession.
They are already put in possession by good team.
Who?
Appellants.
No. How can the trial court direct recovery of possession without passing an order for partition?
My lord, in my normally.
Means, where possession, if it is delivered, where should the possession be delivered? Yes, they have a good right for all these things. They have a right of 1 katha 12 lectures. Not quarrel with that. That part is okay. Now, only sale deed which is being challenged is the 2 kathas. 2 katha sale deed is being challenged. But there is no challenge to the 89 deed and the 79 deed. It is both the 89 deeds. What happens to the 89 deeds? Others may go.
Lordship, in the plain, there is no challenge to any sale deed lot. Lordship is pleased to peruse the plain. But the learned trial court have passed the decree, declaration that the sale deed in respect of defendant number 3, Nawaz Kumar Sharma, is void. Whereas there is no prayer or any whisper in the plain.
Gifted having
Lordship.
shared but partially void, there is no requirement of telling the sale.
It is a time barred lordship.
Those deed which automatically go.
Lordship, the gift deed is dated of 1981. And this TS title suit number was filed in 91. That your lordship will get at page
No.
8.
The trial court did not set aside the gift deed. Trial court did not set aside the gift deed. Didn't it?
The trial court certified lordship.
Huh?
The gift deed are declared void.
Where?
Yes, lordship will come to the judgment.
Page 58 with
Yes, what is it?
what sale deed,
Sale deed is declared void. Where's the gift deed?
page 53 man.
8?
In the plain, they had plaintiffs have prayed for cancellation of the gift deed.
Well, page 54, second paragraph. Exhibit A, there is a gift deed. Last line says exhibit A has no legs to stand in the eye of.
Hence, exhibit A has no legs to stand.
Right.
No legs to stand, but where is the declaration?
It is void.
Where is the declaration that it is void?
And funniest thing is this lordship, there is no prayer
The
in,
first appellate court judgment, lower fee.
that is more perverse lordship, nothing, no provisions of
Page
order
29.
41. Order 41 has been followed. It has been written just like a short story. Page 29 is the judgment by the appellate.
No, but the problem is the, Sundar, how do you take care of that?
I'm
Don't you think when you are asking for partition, you have asked for partition also, can you see here?
Yes,
A decree for
partition period is
partition,
there.
if the constitution, the court of partition is necessary for recovery or possession of the same may be decree. Now, who is the prayer? Page 14. The trial court ought to have granted this relief.
And the plaintiff has prayed in the plain lordship there is no prayer for the confirmation of possession, but the learned trial court passed the decree for confirming the possession. Whereas plain there discloses recovery of possession.
Now, Mr. Mudumdar,
Well-
you see section 44. The transport of fear. If the declaration is given that the plaintiffs are entitled to 1/12 acres of land. The question is, the learned trial court as well as the first appellate court ought to have granted the.
Which part of the entire? One cut of ten sir, from where?
Can you see this? Now, section 44 says,
I'm reading my section.
section. Section 44 say that any gift or sale, whatever may be, can be only possible to the extent the land has been given. To the extent they have a right over it.
Tell me that.
His right was 2 cutters. But now, he has shown anything more than that. Then in that regard, that part will be bad. Now, what he does, the trial court does, says the entire gift deed is bad. Says exhibit A is has no legs to stand. Okay.
Yes.
Now, 85B is set aside.
Yes, what did it?
That's- Now, if 85B is set aside, but a gift deed is not set aside.
Seems to be, who likes to send this, the gift it is.
Ten legs is okay, but for a registered instrument, can you say no legs only?
Read the judgment, it's very difficult to understand this is how they've written the judgment.
So it's okay.
From their point,
Okay, but the question is, how does this work? Give you the benefit. I can't just dismiss the appeal like this. Dismissal of the appeal, yes, you have a case, there's no quarrel with that, we have a case. But it's the fault of the court that courts below, in not properly formulating the limits.
my submission will be, your lordship, is as cut short the matter. In the written statement, they are also ultimately admitting the fact that yes, I am entitled to 2 kata 10 less, 2 kata 8 less acre. So what remains now is that I am entitled to the remaining part of 1 kata 12 less. or 1 kata 10. Or she may direct that. Because it's a revenue paying estate. We collect that. They themselves are saying the revenue. Time it up.
But they mentioned about the deeds of sale of 89 in the written statement.
That is.
I think the defendant number 3 has filed a separate written statement or together.
Separate,
Let us see his written statement.
page 17.
Schedule itself is most vague one. Nothing is clear in this schedule. It will start from page 14. Possibly pleased with that schedule one
Page-
bigger, one
page
kata of land.
21, paragraph. Defendant number 3 was in need of land and defendant number 4 agreed to sell 1 kata 6 pieces of land from Star for a sale consideration of 20,000. On 10/1/89, the defendant number 4 by specific boundaries sold the same by registered sale deed in favor of defendant number 3 and delivered for his. Twenty-three 85 sale deed is mentioned in paragraph.
Now tell me, they say about patta number 35 and old patta number 43. It had 2 bighas of land.
Yes.
So it was joined. But
Right,
then
right.
in that case, how do you take care of it?
No, also kindly see for the page 20, paragraph 4. First sentence says the suit land covered by new patta 35 and old 43 comprises 2 bighas of land in total. Next sentence, in one dag there is 1 bigha, 1 kata of land, and in another dag there is 4 kata. In the same patta, Umesh Chandra Das and Kamal Das had their.
Now here it says another thing.
And-
What is you are saying is different. Please see form.
Oh, yes.
The 28/3/1985 deed is of 4 kathas. Isn't it? That is why you find the D4 selling. Now things becomes better. Now this is declared to be void. 85 is declared to be void.
Yes.
Once it is declared to be void, it cannot be void in entirety. It has to be void only to the extent of
Except.
1 katha 12 lectures. Isn't it? So we interfere with the appeal by holding in the earlier that the sale deed would be only void to the extent of 1 katha 12 lectures. Because while you were making the submission, you said by the sale deed of 28/3/1985, it was mentioned as 2 kathas. Then it becomes a difficult proposition. 23/2085 has is it exhibited.
Yes.
These people also, they don't, it is exhibited, plaintiff exhibit number 2. Let's see what is that.
Exhibit number 2.
then you can get a partition. But once you ask for partition, the court should have granted the partition. The court would not have granted them. So that portion of the relief also has to be interfered with. The court could not have granted recovery of first possession unless and until there is a partition. Isn't it?
Total land. Out of the total land, 1/10 is the formula and get degree. It's a
You
problem.
will get that. Put that away. So, his first substantial question of law is proper. Yes. It is 85 document. I think there's nobody. Failure had happened in 85. So the defendant number 3 did not bring on record the sale deed. You did not bring on record the sale deed.
Held it.
Ah,
So it was
no. You have not exhibited the sale deed. You have not even mentioned what is the number, what is the date of the sale deed even.
in the WS, it is not. In the WS,
Then how can you have any sale deed business out there? You have not mentioned anything.
the burden lies on the plaintiff.
No, it is upon you to show that. You have not mentioned when did you
Because
purchase
in the
it.
plaint, my lordship, my
Anyway,
sale deed
all
has
these
not
things
been
will be
challenged.
subject to
Your
a,
lordship, will please to note, in the plaint, sale deed has not been challenged.
not necessary. You have also not mentioned that there is a sale deed. Number is not mentioned, nothing. You said that the boundary sold the same by a registered sale deed in favor of the defendant number 3. How much?
Underline in pencil. Hold on.
Sari kotha.
Yes.
So these 4 kathas have been sold. So therefore it makes sense now. So the question how it can be done is, question of recovery of possession should not be given. The court should therefore, this court needs to exercise order 5133 and say that the question of recovery will not be there, but you will have a right of partition. The partition is that your right is 1 katha of that land. So that sale is only interfered with to the extent of the katha. Italy. 2 katha is interfered with 1 katha 12. The sale deed of 1980. Now, once that is interfered with, some remaining will come. Any sales have happened because there's nothing to. I think that is the only way. Mr. SP Roy substantial question of law survive,
Lordship, may please to come to the,
not necessary. The substantial question of law survives.
I had submission on the point of limitation laws.
Huh?
It should was time bar laws. Lordship, may please to come to the plain. Page, start from page 8. Page 8, Lordship, may be pleased to peruse. Earlier, the suit was CS number 691. It was renumbered subsequently when the case was transferred to other court, Lordship. As TS number 2003, 2007. So, Lordship, when they give deed, in the plaint, Lordship, only the gift deed has been challenged, no any sale deed. So, limitation for the cancellation of the gift deed is 3 years, Lordship.
Where's the guilty?
Lordship.
They had no knowledge.
They have not stated which part date of knowledge had not been disclosed in the plaint, Lordship. I may be allowed to read the plaint. There is nothing known which part. And both the courts below failed to give any finding regarding the limitation. Lordship, may be pleased to peruse page 13 of the plaint, para 10. There is no show any cause of action. The plaint was liable to be rejected under order 711A of the CPC Lordship.
Where in second appeal?
Lordship.
Let us not go to depths.
The cause of action was actually from the date of if deed Lordship. Here in para 10 of the plaint Lordship, the cause of action has been shown on 8/12/90. There is no cause of action. How the courts below can decree a suit when it does not disclose any cause of action?
And here you, Mr. See the question of limitation which is there. trial court went in a different, did not go into 58 properly. Now, the question is, on one hand, if a person is asking for right of partition, and there is a sale deed being made, that is, you're asking for cancellation. Now, there are many judgments when the cancellation is being sought over a sale deed, of a sale deed of a document, on the basis of which your title survives. Then in that regard, the limitation would be, well, yes, but there's no more to it. Here, recent judgment. Went with another case. It's a judgment by, I think, Sanjay Karol, this is Sanjay Karol. See into that. Here the gift deed was challenged and for recovery of possession. Now the question is, once the gift deed was challenged, it becomes a suit for title. There was a gift deed given and there was a revocation of the gift deed. So that revocation of the gift deed was put to challenge. And when that revocation was set aside, the court said, then the consequential relief which is being sought for recovery of possession becomes the main relief for for limitation. That is 12 years. That is death jail. But there is also another recent judgment which has been given by Justice Dipankar Dutta. Very recently, another one, very recent. There's another judgment of Justice Padiwala. This is 2024. That is also, I'm not finding it here. I took it up for another matter. Wait. Judgments. Judgment 2023 17 SCC, page 400. 2024 SCC online SC 3846. Please, I'm not sure. Now this 2024, and there is another judgment of Justice Dipankar Gupta, wherein he says when you seek for cancellation of the sale deed along with recovery of possession, the moment you fail in the seeking cancellation of the sale deed, then it becomes a death suit. Then you don't have then the limitation goes as per section 3 or for 3 years. But if you are successful in challenging, then it becomes a suit for title. And then it becomes 12 years. Okay. The hearing matter having been heard at length, is the matter for further hearing on 15th of May 2025 to the top of the list.
13th of
May. Thirteen or 20?
20.
28th of. So there, I think then the limitation is being taken care of. Although the trial court mentioned it, but in not so good words. But it went into 58, but say that it is not a case of adverse possession, therefore it went